Good morning. If you could please join me for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. With that, I open the public hearing on House Bill 146 and invite the prime sponsor to introduce his bill.
Thank you, Mr. Chair, and the members of the committee. And also, let me thank you for changing the date. Unfortunately, I wasn't around the week that it was originally scheduled, and I certainly appreciate the time. I was going to bring some donuts, but then I realized you can't have food in the committee room, so that problem solved. Yes, right. Yeah, but I know you're not a police officer. There you go.
Firefighters eat donuts too.
Anyway, for the record, Jack Flanagan, represent Hillsborough 45, which is a flotorial of 4 towns. That would be the towns of Hollis, Brookline, Mason, and Greenville. Quite large geographically. The bill that you have in front of you was generated because of a constituent issue. He got a moving violation. A state trooper had pulled him over. He was with his Down syndrome son and alleged speeding. What happened was he disputed the claim, sent it in within the 30-day window that you had to dispute the claim. Emphasis on 30 days to put in the dispute. And then he waited for the court to assign a date. Now, the issue that the constituent had was that the state trooper was riding the back of his car like road rage. His behavior was out of control, and he wanted to use the video camera as evidence for the behavior and the conduct of the officer. So he complied within the 14-day window of the date for a discovery request. But then when he asked for the videotape, he was instructed that they don't keep the videotape past 30 days. So literally, the videotape, which is exculpable evidence, basically is destroyed even before he might have the chance to ask for a hearing. And then on top of that, if he does get a hearing, it's well past the 30 days for him to receive the evidence that would be help prove his case. I'm just looking at my notes, bear with me. So the issue really here is his rights were basically, because of this policy the state police have, were trampled because he could not present his case and prove his case. I have notes here, but I can't even read my own handwriting. So, requested only those held. Oh, the other thing too is, and I'm not, our former brother-in-law was a state trooper, but my gut feel is that if the videotape absolutely proved the sincerity, the seriousness of the claim, that tape would be kept. In other words, they would have taken it upon themselves to keep it. So I don't understand how a person who was trying to defend themselves wouldn't have access to the same video camera past the 30 days. And, I remember what that note was, is that the way the system works is after 30 days, they get rid of the tape. And my thought process was, okay, hold everything till the 30 days. And if you receive notice of the request for the hearing, keep only those in the cloud where they keep the videos now. So in other words, it's not a massive amount of recording being saved. It's only specific to the ones that they're disputing as it relates to the validity of the claim. Did that make sense?
It does. And I'm pretty sure they already have a process for criminal cases. So it maybe just having to mirror that, but we'll find out when we talk to the trooper.
I'm sure they'll come up and say the other, but I guess the issue here is fairness and the exculpatory evidence. You know, it is truly part of his defense, and if it was a much serious claim, and I will tell you, to digress is a little bit, is that the judge realized when he got into court, realized that there was a problem, but there was nothing, no legal precedent that he could use that would basically throw it out because of failure to provide discovery. But what he did do was he reduced the penalty, the monetary penalty, knowing that now he's relying upon basically the statements of the trooper, which they have to abide by because they're officers of the court. But it still didn't allow the constituent to present his side of the story, and I think it's totally wrong.
Thank you. Anyone here have any questions? Representative Rhodes.
Thank you, Mr. Chairman. Thank you for taking my question. So we did open up the public hearing when it was originally scheduled. And of course, as you know, it was continued. But we did hear that the info is required for 3 years if there's a court hearing. And the concern was going to be having different time frames for different circumstances would just cause overall confusion for the public and for the departments. What would you be your thought on that, or how to solve that?
Sure, I'm a little confused, and I'm not avoiding your question. So when you say different time frames, meaning each crime has a different time frame for retaining the information?
So if I may, Mr. Chairman, so we heard from the assistant district attorney, I believe from Merrimack, and said that there would be confusion with multiple timeframes, charges oftentimes reduced. So if my understanding, like the chairman was saying, if it's a criminal charge, that time frame is, I don't even know what the time frame is. But they also said that if the case is going to court, it has to be held for 3 years, right? So then, but if this was not like, so you asked for it to be held, like you're saying that was 30 days. So there's a standard 30 days, which it sounds like it was held for that amount of time. So if there's different time frames, because they're also thinking the cost, right, for the downloads and the storage is, exponential for all of that charges. So that was the concern that the attorneys have and the different agencies have. So I was just curious if you had a thought of how that could be handled.
I'm still a little confused on your question, Representative, because
You might just, it's okay. You might not.
no,
know the
no,
answer
but
to
I
it.
want to answer your question. I don't want to ever not answer your
I
question.
think what, if I may, she may be saying is that, so you have the criminal cases, they have to hold these for a certain amount of time.
Sure.
For a civil case like this, it would almost be a rolling type of thing, because you'd have some cases where you'd have it, 30 days from this day, next month you got 4. So then having to keep track of all those dates, I'm not sure how they would do that, knowing how long to keep each one, when to destroy it. I'm not sure. I'll have to ask them, really.
If I understand the question, and
Yeah.
my initial response is, I think the person's rights, regardless of the severity of the issue, should be maintained regardless of the crime itself. In other words, the process needs to accommodate everyone, and everybody should have that same right, whether it's just a violation for speed or, in fact, they pull them over and there's 30 heads in the trunk of the car, right? I mean, you can't just say, well, this crime or this violation has only this duration for the video, because the person had 30 days. He fell within the parameters of the process. That is, he disputed it. Okay. But the evidence was no longer there. And I think that's wrong, just fundamentally. I hope I answered your question, regardless of the time frames.
Yeah, I tend to agree, because it just made me think of something. If that citizen had got out and struck the officer and that was captured on the tape, that tape would still be there.
Oh, betcha.
Yeah.
You betcha.
So the fact that it would benefit the citizen that's not there. So yeah, I'm going to look into that. Thank you.
No, thank you.
Seeing no further questions, thank you.
Thank you very much. And again, Mr. Chairman, thank you for allowing this to go the extra week. I certainly appreciate it.
Yep. Chair calls Major Davy.
Good morning, ladies and gentlemen of the committee. Thank you for hearing me. My name is Brendan Davey. I'm a major in charge of the Operations Bureau with the New Hampshire State Police. I am here today to testify in opposition to this piece of proposed legislation. I will point back to Assistant Merrimack County Attorney Steve Endres' testimony last week when this hearing was initially scheduled. He made several good points, including that if this law were to take effect, that it would be to require that certain evidence be treated differently than other evidence in terms of the standard for discovery. It would also serve as a means by which to disincentivize agencies that don't currently have body-worn or cruiser videos from engaging in their use, because they wouldn't want to take on the headache of that disparate treatment of one type of evidence versus another type of evidence.
As I wasn't here that day, could you just summarize for me what that testimony was with regard to types of evidence?
Yes, sir. Specifically in this proposed piece of legislation, that recordings made of motor vehicle violations for which a summons was issued would be required to be turned over to the defendant within 5 days of any request therefor, which is to set a different legal standard for that evidence as compared with all the other evidence that would become a part of discovery in any normal case.
So if it matched, would there be a problem?
If it matched, there would not be a problem. And in fact, there isn't a problem because it does, in fact, match. The law on body-worn cameras provides for the retention of video for no less than 30 days and up to very, very high limits. As a matter of fact, in the state police, based on the classification of a video that we have in our system, many of them are 100 years.
Yeah.
Because of civil liability and the statute of limitations thereon, even those cases that, excuse me, we suspect or have reason to suspect are going to be part of civil litigation, our minimum for those is 4 years. When it comes to a normal, everyday, unremarkable, we'll say, traffic stop, whether it's a warning or a summons, 30 days is our minimum. Whenever we get a complaint that our troopers have been discourteous, otherwise unprofessional, or behaved in an unlawful fashion, then those videos are saved and their retention period is significant, so that we have all the opportunity to refer to them in any litigation that might come, whether it be a civil lawsuit or otherwise. So what already is in place is a balance that is governmental efficiency of operations on the one hand and constitutional rights, or the ability to make complaints about professional behavior and our obligation to provide professional behavior to our constituents. As far as the notion that in the case that spurned this piece of legislation, the defendant's constitutional rights were abridged, I would only answer that by saying the defendant was in court for an allegation that he violated the law by speeding. The case that another vehicle, in this case allegedly driven by a New Hampshire state trooper and allegedly far too closely to the defendant, is not necessarily and directly material or evidentiary as far as the defendant's speeding. That said, we have an interest in knowing about it all the same, and I would argue that had the defendant in the case that allegedly spurned this piece of legislation called and complained and said, look, I got pinched for speed, but the only reason was because I had a vehicle almost touching my rear bumper and it was driven by one of your troopers, well, then we would have looked into that. So all that to say that generally speaking, the circumstance which leads to this proposed legislation is pretty unusual, and certainly not a part of our design, but the law as it stands works fairly well. There is in Senate Bill 289 some work on the body-worn camera standard in RSA 105D2, and I would submit to the legislature that if to prevent any such case as that which spurns this hearing from happening again, then it's certainly within the legislature's purview to say that that in no case shall a recording made be dispensed with, deleted, sh- less than 60 days or 90 days.
That's what I was actually thinking. It seems to me, so in this situation, the driver gets a citation. Well, your point is correct. He could have called and made a complaint, but the instructions he received from the trooper would have said you can file an objection to this citation within so many days with the court. So he naturally did that. And so, and when you said, you know, if he would have called and said the reason I was speeding is because there was a vehicle on my bumper and it happened to be your trooper, that would have indeed, I think, been relevant in the hearing. So it seems to me that if you would have held on to the tape had he committed a criminal offense, because it would have been evidence of that crime, he should have access to it so long as he has an avenue to appeal the citation.
Yes.
So if the citation is a 30-day window, and generally it's probably going to be another, month after that before he even gets into court for his citation hearing?
I think it would depend on the court, but
Yeah.
they're not particularly quick.
Yeah.
Yes, sir.
So I think your suggestion of 60 days, just a flat 60 days, just double the time period would cover that without having to get into the minutia of why, just
Yes, sir.
period. So,
Yes, sir. Lastly, the point that I'll make is with regard to volume in terms of efficiency. The state police issued 32,369 summonses in calendar year 2024.
32,000?
Yes, sir. And there is, of course, a cost with lodging videos in the cloud. We have several terabytes at this point in time, having launched our program in the spring of 2022. And obviously that is very expensive. Many agencies can't sustain the cost for that. The body-worn camera project in and of itself was in response to an order of the governor and the Lee Act Commission's 48 recommendations. We have used and had a plan to use cruiser cameras. The body-worn issue in a state where people enjoy their own liberties, particularly in personal property, is it can be tricky in New Hampshire, but that's a lot of data and a lot of expense, particularly for small agencies to bear and for our agency to bear as well.
Do you know what the increase in cost would be to keep it for an additional 30 days?
I do not know.
Okay. Okay. Do you think you could inquire and get back to me?
Yes, sir.
If it's possible to determine that?
Yes, sir. Happy to do so.
I'd appreciate that. Thank you very much. Any further questions for the major? Seeing none, thank you for your testimony.
Thank you.
Anyone else wishing to testify on this bill who hasn't testified? Seeing none, I hereby close the public hearing. Reopen at 10 for the next hearing. Good morning. I'm opening a public hearing for House Bill 638, and I invite the prime sponsor to introduce his bill.
Thank you, Mr. Chair, members of the committee. For the record, my name is Representative David Muse. I represent the people of Portsmouth, Newington, and Newcastle, and I come before you today to introduce House Bill 638. While this bill has already received some attention because at some point it would impact the parole eligibility of a person who is at the center of a very famous case here in New Hampshire if it passed, I want to be very clear that this legislation is not about a particular individual or about a particular case. What it is about is weighing the cost and benefits of unending state retribution against people who may no longer pose a threat to society. What HB 638 would do is make it possible, even for people who have received the harshest sentence of our criminal justice system, to earn a second look into their incarceration from society and our criminal justice system, and the possibility of mercy in their elder years. In our state, the penalty for the intentional killing of another person with premeditation or while committing certain crimes is life in prison without parole. At the end of 2024, there were a total of 95 people in our state prison system serving life sentences without parole. Under the bill, those people would automatically become eligible for a parole hearing when they turn age 60, provided they've served at least 18 years of their sentence and as long as they haven't committed a major conduct violation in the past 10 years. According to data the Department of Corrections provided in the fiscal note, 15 inmates would have been eligible at the end of 2024 under the parameters of this bill, but that number could change slightly over time before the bill takes effect as other inmates become newly eligible and as some may pass away. To be very clear, this bill is not a get-out-of-jail-free card. All it does is make a very small number of people eligible for a date with one of the toughest parole boards in the Northeast. Something that surprised me in the fiscal note, and I'm sure it surprised some other folks on the committee too, is that the annual cost of incarcerating a prison inmate in the general population is now estimated at $78,542. In my time on this committee, the figure we've most often seen has been closer to $35,000. Something to keep in mind is that older inmates often have significantly higher healthcare expenses and that prison can be a very difficult place to practice good diet, exercise, and good health habits. But even in prison, there are no walls that can keep out the challenges that often come with old age, like heart disease, deteriorating joints, strokes, and dementia. Older inmates cost more and present unique challenges to corrections staff. While this bill won't eliminate those challenges, it could ease them. This bill would also in no way impact the constitutional ability of the governor to pardon or commute the sentences of people in this situation. But what it would do is provide another avenue for people to make their case. It would simply provide those who qualify with the opportunity to present their case before the parole board, and the parole board would then make a judgment based on the facts and based on the person's suitability for release. Something I would like to point out is that under this bill, prisoners convicted of capital murder under RSA 630-1 would not be eligible. The elephant in the room for a bill like this is actually a small woman who has spent much of the last 3 decades in prison in New York State. While Pamela Smart can't be here today for obvious reasons, she has written a letter to me supporting the need for the bill, which I've shared with members of the committee. You can read her letter for yourself. I want to be very clear that I am not here to defend Pamela Smart or to advocate for the release of a person convicted by a jury of her peers. That's for people with a much higher pay grade than me. What I am here to do is to advocate for her ability to get a hearing. Prison is not just about rehabilitation. It is also about punishment and retribution. What this bill asks us to decide is whether there is a point where our need for retribution as a society can end, or if there is always a need to continue it. even when it comes to elderly people imprisoned for decades who are only asking for something that every other inmate in our prison system is eligible for, a hearing before the toughest parole board in the Northeast. I ask you to give this bill your consideration and a not to pass recommendation, and I will take your questions.
Thank you, Representative. Representative, does your bill have a contingency where it asks the victim or the relatives of the victims if they would support the parole?
It does not, but I want to point out that our parole process does allow for that. So victims would have the ability to weigh in, as they do now, in cases that come before the parole board.
Thank you. Representative Rhodes?
Thank you, Mr. Chairman. Thank you for taking my question. I will say that you did answer a couple of them about the average time and so forth. So thank you for that. I'm just curious. So my understanding is it's about $237 a day for an average person that's incarcerated. Do you have a number or have given any thought to, so if the person is serving a life sentence, they've been incarcerated for at least 18 years, is what I think that you had said. How would that person go about supporting themselves if they were to be released, as far as housing, career, transportation?
I believe that is part of the parole process. It's not only whether you qualify, for parole based on things like your behavior, it's whether or not you actually have a support network on the outside. So that's something that that's something that that would have to be in place, for somebody to receive parole in a situation like this.
May I follow up, Mr. Chairman? So just to follow up, when you say something in place, I'm specifically thinking, are you thinking for the public to be responsible, or for them to actually get themselves a career and in their own place to live and so forth?
It's a place to go, and my understanding of the parole system is that sometimes people are paroled, and they are paroled into things like halfway houses and things like that, where they can kind of get some type of assistance before they actually have to go back and earn a living and like everybody else. In a situation like this, I would probably hazard a guess that these folks would have help from people on the outside.
Any further questions? Yes, Representative Paquette.
Thank you for taking my question. I just wanted to know what the rationale is. You said elderly prisoners over the age of 60. And I'm just wondering if there was any rationale that led you to choose 60 as being a number.
I'm sorry, could you speak into your microphone a little
Yep.
more? Thank you.
I was just wondering what your rationale is, or was, to choose 60 as the age, over 60.
I think part of it is I don't think we wanted to have a lot of folks be eligible right away for this. So I think when you by choosing 60 years as the minimum age and a minimum of 18 years served, it really narrows down the number of people who would be eligible for something like this. So I think we're always in a position when we make up laws, we sort of have to make up cutoff points and things of that nature. But one thing I can tell you, having been age 60 myself and now being older than that, is that that's when a lot of healthcare issues really do start to rear up. And one of the things to keep in mind, and you'll have this opportunity, we'll probably all have it later in the session, is when we take a tour of the state prison, is one of the things that will strike you immediately is this is not a place where you're going to have lots of access to healthy eating and exercise and good diet, and it's a very hard place to stay healthy, and you're also in a situation where you're crowded in there with other people, and it's very easy to get communicable diseases, and things of that nature. So the bottom line is while some of us on the outside may be pretty hale and hearty at age 60, my guess is the average person in our state prison system probably isn't quite as healthy.
Thank you.
Yep.
See no further questions. Thank you. Okay, just so everyone knows, we have, it looks like in excess of a dozen cards, so we're going to limit testimony to 3 minutes. Please keep that in mind. If you have testimony written, turn it in, don't read it to us, and try not to repeat what other people have said. With that, I call
Alexandra Bailey.
Alexandra Bailey, please.
How are we doing? Oh, there we go. Okay. Good morning, Chairman, honorable members of the committee. My name is Alexandra Bailey, and thank you so much for hearing my testimony. I am here as a two-time survivor of violent crime, once as an underage sex offense that was part of a double homicide that resulted in a life without the possibility of parole sentence. And then as a grown woman, unfortunately, as a survivor of domestic violence. I'm an advocate for domestic violence survivors all across the country and have been central to passing laws for criminalized survivors who are serving long or indeterminate sentences. I also have the honor of being the chair of the board of Drop LWOP New England, which my colleague, Dr. Brashani Reese, founded and asked me to chair because she is a fellow survivor of violent crime. But I'm actually here today to testify in favor of this legislation. I do believe that there can be both redemption and responsibility taken by people who are harmed. The study that will be quoted later on, which was the first national study ever done of how victims feel about second chances, including those who have survived violent crime, I was actually interviewed for. So I'm actually part of that study, and what you will hear is that a large percentage of survivors would actually like to see rehabilitation and second chances and restorative justice be the thing that is enthroned within our system, as opposed to perpetual punishment. But as somebody who has helped people who are very senior and elderly leave prison, one of my most recent successes is a woman in Oklahoma who served 34 years of incarceration simply for surviving domestic violence. She didn't even kill her husband, her brother did. And she was serving a life without the possibility of parole sentence. Life without parole sentences do not allow the system to go back and review. It does not allow for relief, either fiscal or moral. And so this type of legislation gives the courts a very narrow, in this case, a very, very narrow opportunity to both provide redemption, but then also to allow to unburden your system. One of the things that our sponsor pointed out is that 60 years old out here might seem robust. The studies that have been done on this would suggest that 55 is elderly in prison for very obvious reasons. You're obviously living in a very difficult environment, at times a violent environment. Injury is often not treated, adequate medical, adequate food. A lot of studies show that people are actually 15 to 20 years older physically than they are numerically. So what you're going to be dealing with at 60 years old is what you might be dealing with at 70 or 80 years old in terms of health. I think the last thing I would like to say is that victims are not a monolith. I understand and respect people who have survived violent crime. I'm one of them. But also, some of us forgive our perpetrators, and we're often not heard. We're not given that opportunity. So please listen to both sides today. Thank you.
Thank you for sharing your story. Chair calls Russell Rocks. Oh, Roy.
Good morning, Mr. Chairman, members of the committee. My name is Russell Roy. I'm a private citizen living in Manchester. The chairman and I aren't related to the best of my knowledge.
Does your family come from Canada?
Yes,
We may
we
be.
are from Canada, yes.
Buck Tush.
I apologize for reading my testimony this morning. I'm a little bit nervous up here, and you don't want me meandering. If you'll indulge me, I'm going to share a brief story with you. Many years ago, right here in Concord, two young men were friends with a common bond. Both were addicted to pills. 20-year-old Gary's narcotics addiction came about as a result of painkillers he'd been prescribed when, at age 16, he was hit by a car at high speed and seriously injured. 17-year-old James's circumstances is unknown to me. But one night, strung out and drunk, the two joined a bunch of other young people in various stages of intoxication, partying out in back of the New Hampshire State Liquor Store. Among the partiers was a 19-year-old Michael Stitt, an acquaintance of theirs who happened to owe Gary a $20 debt. It wasn't long before Gary was up in his face about it, and tempers flared, and the pair began to grapple. It was then that James threw a knife on the ground at his friend's feet. Impulsively, Gary picked up the knife and stabbed Michael 3 times, killing him in cold blood. The pair ran, but it wasn't long before they were apprehended, arrested, charged, and in separate trials convicted. First-degree murder, life without the possibility of parole, an extreme sentence for a horrific crime. That was in 1976. 8 years later, in 1984, James Smith, the younger of the two co-defendants, just 17 at the time of his conviction, committed suicide while serving out his life sentence. And today, in 2025, at age 69, the older of the two, Gary Prayer Feather Farrow, remains in prison, having served 49 years, almost half a century, for his actions on that fateful night. He is currently the longest serving prisoner in the state of New Hampshire. Ladies and gentlemen of the committee, I can say without equivocation, each of us must be accountable for the decisions we make in life, for the actions we take, and especially when one is the cause of great harm. However, there is no amount of years served or reparations made or sorrow expressed that can ever fully make up for the taking of another's life. This much can be said, though, to as great an extent practicable and within the constraints of our rehabilitative correction system, Gary Farrow has expressed remorse for his crime to whomever would listen. Over his years behind bars, has earned an associate's degree in business, become an accomplished woodworker and artist, remained behaviorally trouble-free, and for the past 2 decades has been a devout adherent of the Lakota Sioux faith tradition, who have welcomed him into their community. I ask you, what purpose beyond retribution is served by insisting that a rehabilitated elderly person, such as Mr. Farrow, draw his last breath from behind bars? Providing an opportunity for individuals such as Mr. Farrow to make their case of sincere remorse and accountability before the parole board and the community at large, who remain the final arbiters, is all that we ask and what this bill will accomplish. I humbly ask that you search your heart and provide some measure of hope for elderly prisoners by casting your vote in favor of this legislation. Thank you for your time, attention, and consideration. And I'll entertain any questions.
Thank you for your testimony.
You're welcome.
Chair calls Sarah Mattis.
Good morning, Chair Roy, Vice Chair Rhodes, and the respective members of the Criminal Justice, Public and Safety Committee. My name is Sarah Matta, and I'm speaking in support of HB 638. I believe it is essential to create meaningful parole opportunities for those aged 60 and above who have served at least 18 years in prison, individuals who can demonstrate growth and rehabilitation, who pose no threat to public safety, but deserve a chance at release. First and foremost, I want to make it clear that my support for this bill does not diminish the pain experienced by victims and their families. Rather, the goal is to promote forgiveness, redemption, and healing for all involved. Many of us assume that harsh sentences bring relief or closure to the families affected by the actions of our loved ones. However, the reality is that harsh sentencing does not provide true justice. My loved one and I understand that the actions he made at age 18 created a ripple effect, much like that of a stone skimming across the water. This ripple extends not only to the victims, but also to their families and the families of those incarcerated. The purpose of his bill, as Representative Muse said, is not a get-out-of-jail-free card, but to provide individuals who are eligible with the opportunity to believe in their capacity to change. It gives them a chance to transform their lives, take control of their thinking, and reconcile with their past actions, fully understanding the far-reaching efforts of those actions and their consequences. As he and I reflect on the 26 years my loved one has already served, we come to realize that he had two choices. One, blame society, his youth, lack of education, etc., thus becoming what we would consider a hardened individual with no regard for society or his own accountability. The other is the one he chose. The length of time he has and is serving is an opportunity to make better choices, work on changing his behavior, take accountability, and transform his thinking and his compassion for others. This transformation ensures that he and other inmates like him will never walk down that same destructive path that led them to prison in the first place. This bill acknowledges that a young person entering prison at age 18 is not the same as someone leaving at age 50 or 60. Statistics show that with a supportive family and educational opportunities, recidivism rates and reoffense percentages are significantly lower. In fact, harsh sentences like life without parole or LWOP do not deter crime. Instead, when inmates are given the chance to change, whether through formal education, learning a trade, or personal growth, they can become productive members of society. Here in New Hampshire, we live among many former inmates, some are my friends, who have spent 25, 30, or even 35 years in prison. Today, these men and women are remorseful, hardworking individuals who are giving back to their communities. We don't often hear these stories because they don't fit that lock them up and throw away the key mentality, but they are a testament to the power of second chances. For these reasons, I urge the committee to vote favorably on HB 638. Thank you for your time and consideration on this vital legislation.
Thank you for your testimony. The chair calls Mallory Lee.
Good morning. As an in-home therapist and manager of treatment in the community, as well as a formal clinical case manager at the Northern New Hampshire Correctional Facility, I've spent my career working with individuals who have endured immense trauma and hardship. My role has allowed me to witness firsthand the transformative power of rehabilitation when individuals are provided with meaningful opportunities for growth, self-reflection, and accountability. I am speaking in support of a proposed bill that would grant parole eligibility to incarcerated individuals aged 60 or older who have served at least 18 years of a life sentence for first-degree murder, provided that they have maintained good behavior over an extended period. This legislation acknowledges that rehabilitation is possible and offers a pathway for those who have demonstrated genuine transformation to reintegrate into society. One such individual who exemplifies this possibility is Mr. Gary Place. Although mental health and rehabilitative programs are readily available in correctional settings, participation is not a requirement. Many individuals decline to engage in these opportunities, but Gary has demonstrated remarkable self-motivation in utilizing every available resource to foster his own growth. His record includes pages of documented participation in rehabilitative programming, not only as a recipient, but as a facilitator and leader among his peers. He has chosen to engage in intensive therapeutic interventions, skill-building initiatives, and wellness programs that address all domains of rehabilitation, including mental, emotional, social, and vocational wellness. His rehabilitation has not been passive, it has been holistic, intentional, and impactful. PTSD is an area of particular concern in my field, and throughout my career, I have seen its devastating effects on individuals across the lifespan, from young children to adults. The psychological and physiological impacts of combat trauma are profound, often manifesting in ways that are not fully understood until decades later. Gary, like many veterans, returned from war carrying the weight of experiences that changed him. He was trained for combat and conditioned to survive in high-stress environments, which deeply affected his mindset and responses to danger. At the time of his offense, the long-term consequences of PTSD were not as well understood as they are today. While we still have much to learn, what we do know is that individuals who engage in consistent, structured therapeutic interventions like Gary can successfully process trauma, develop coping mechanisms, and lead meaningful, productive lives. Beyond his personal transformation, Gary now serves as a leader and mentor within the prison system. He has helped others take accountability for their actions, develop self-awareness, and create tangible steps toward personal growth. His work has had a ripple effect, inspiring fellow inmates to engage in the rehabilitative process, which ultimately benefits not only individuals, but the broader community. Furthermore, Gary has a robust and well-structured reentry plan, supported by a dedicated family unit prepared to assist in his transition. His vision for the future is not only centered on his own success, but on helping others thrive and grow. Okay. For these reasons, I strongly urge you to support this bill. It is not only a matter of fairness, but of recognizing the true potential of human transformation when given the right tools, guidance, and support. Thank you.
Thank you. And as a reminder, if you do have written testimony, you can pass it in and we'll review it. Thank you.
Stephen Foster.
The chair calls Stephen Foster.
Good morning, Chairman and members of the committee. Thank you for having me here today. This is going to be essentially long for what you just said. You all have a copy.
I said if you have a copy for us, or if
Yeah,
you have
I
given
gave
it,
everybody copies.
then you don't need to read it.
All right. I want to just go on record.
Sure, absolutely.
Yeah, for the bill 638. I'm retired and disabled, 100% disabled veteran from the U.S. Army. Served in Iraq, did a lot of good stuff over there. And I know a lot about leadership, and I know how to read people. I just finished up 6 years at Northern Correctional Facility in Berlin. I was the business professor at the school, and I had other jobs there, as well as subcommittees and committees for veterans groups. That's where I met Gary Place. What a wonderful guy this guy is. I mean, I know we had a bad day a long time ago, but he's got many, many years in, and it's you see guys come in and they get 20, 25 years, and I believe he was misrepresented. He just turned himself in and just spoke openly without an attorney. And that was how he did. But that's Gary. Gary's a straight up guy. He took responsibility for the bad things he did. And he's been, I'll tell you a little story about Gary real quick, and then we'll wrap up. He's been in there 40 something years, maybe 50 now. And he has one ticket. You know what a ticket is in prison? It's when you do something bad. Well, one day in the 80s, somewhere in 1980 something, he got a ticket for putting some screening in his windowsill to keep the bugs from coming in. That's it. No other tickets. He's just a quiet, and now he's old. And so we talked about the age 50, 60, stuff like that. At 60 in the prison, I've witnessed these people. They're on their last leg. They're of no danger in general. I just want to go on record for saying that my opinion is that of all my life experience, they're not very threatening at age 60. And Gary Place has a special place in my heart. Like I said, I did 2 years in the Massachusetts Department of Corrections as a CO, and 6 years as an instructor for business school. And I think I can speak on this subject, and that's what I want to do. I want to say good things for Gary Place. It's all in here, and I want to thank everybody for your time. I know I'm limited, so read this. It's a good write, and don't read it before bed. No, I'm just kidding. Thank you for everything, guys.
Thank you. Thank you for your service. Who did you serve with over in Iraq?
I was with the 101st Field Artillery. We turned them into an infantry unit, and I also worked for Blackwater over there. As soon as I got on the ground, they came and got me.
I was with the 3rd Armored Division.
Nice. Thank you for your support.
You're welcome. Thank you.
Thank you.
Dr. Bashani Reese?
Good morning. This is just my little prop to make sure that I don't totally go blank. Good morning, esteemed members of the committee. My name is Dr. Brashani Reese, and I am here to testify in support of HB 638. I find myself in an interesting position here because I wear 2 hats in this situation. On the one hand, I hold a doctorate in forensic psychology, specializing and studying violence and risk assessment and dangerousness assessment for the last decade. But on the other hand, I'm a survivor of attempted murder. It's the kind of story that can be quite upsetting, actually, when I share it. I was attacked, choked, dragged by my hair, pistol whipped. As I was losing consciousness, I saw my own body in a river. And the only reason that I survived was because the assailant let me go. Still, despite all of that, I didn't want a life sentence for this person. I wanted him to be held accountable, and I wanted him to change. And it turns out that as a survivor, I'm not alone. My colleague referenced quite a phenomenal study that was done in 2022. It's the National Survey of Victims' Views on Crime and Safety. And it was found that 2 out of 3 survivors of crime prefer shorter prison sentences if you combine that with spending on prevention and rehabilitation versus just simply prison sentences that are as long as humanly possible. Also, by a margin of 3 to 1, survivors prefer having other options to hold the person accountable beyond prison, like required treatment, rehabilitation, mental health care, addiction recovery, things of that nature. And lastly, 3 out of 4 survivors support reducing a prison sentence for a person who is actively engaging in rehabilitation, job training, education, mentoring peers, etc. These perspectives are in line with the survivors that I have worked with in restorative justice, where we are looking for a type of healing that cannot be found through a lifetime of incarceration. I ask myself the question, what is justice? And for me personally, I land on something that includes both accountability and the possibility that that person can change. So I urge the committee, please seriously consider HB 638. Thank you for your time.
Thank you for your testimony. Oh, go ahead, Representative Newell.
Thank you, Mr. Chair, and thanks for taking my question. I believe you had said that you spent quite a long time studying the dangerousness, right?
Yes.
And I'm curious about people within this age group. We're saying 60 plus. What have you found, if anything, what have you found about what is the level of danger at that age or past that age?
Thank you for the question. And just briefly, I would say every person is individual, so you have to evaluate in an individual context. But we've found it's 40 years worth of criminological research that has long established that people age out of crime, and that includes murder. Peak crime rates are at early 20s. That's sort of when it peaks. By the time a person is 45, we're talking about a recidivism rate as low as 2% for any kind of recidivating, not even thinking about violence. Thank you for the question.
Appreciate that.
Representative Murphy.
Thank you, Mr. Chair, and thank you for taking my question. Can you tell me if bills like this have been considered or introduced in other states?
Oh, absolutely. Yeah, I'll stick to New England since we're here in New England. We have a kind of second look bill in almost every state at this point, but the one I'd love to tell you about is Vermont. Actually has a robust second look bill that would be much broader than this, would include a lot more people, not just life without parole, but people serving extreme sentences. And that bill in Vermont has bipartisan support. We have a Republican sponsor on the House side.
Thank you.
Thank you.
See no further questions. Thank you for your
Thank you.
testimony. The chair calls Laura Schuin.
Good morning, and thank you for listening to me. I am here in support of Bill 638, and the reason is that I believe that a person who has been incarcerated for a long time, that has shown remorse, that has done as much as possible that they could do to become a good member of the society that they're in, and to be able to have the hope of being free again. I think that if somebody is incarcerated with for life without parole, that they're going to be hopeless, and most people won't do anything to better themselves. If they have the possibility of getting out again, and that they have to follow certain guidelines, I think that it's a fair thing to have that chance for freedom again. You have heard about Gary Place. He's a good friend of mine and my husband's. I met him about 25 years ago, and he impressed me right from the start. He is one of the few people, from what I've heard, that has gone way over and above what somebody in his position normally would do. So I guess I'm just mostly just here in support of the bill for everybody, not just for Gary Place, of course, but for anybody that would qualify.
Thank you very much for your testimony. Chair calls Donald Ryder.
Good morning, ladies and gentlemen. Good morning, ladies and gentlemen. My name is Donald Ryder. I am a professional logger in the state of New Hampshire, and you'll be happy to hear that we haven't cut all the trees yet. New Hampshire is still the most forested state in the United States. I'm here in support of this bill. I have been in contact with a prisoner in the Berlin jail for 25 years, and what I've learned from him is that people can change. If a prisoner has committed this terrible crime, and he had the ability to use this bill to get freedom, I would think he would have to really, toe the line and be a better person and learn to be a better person. If he does not have this ability, then I think you're going to lose a lot of people through the cracks, and they're going to end up dying in prison, as could be my friend. I really think that, the times are changing. It used to be that marijuana was a terrible drug and so on, and state after state is now is legalizing it, not New Hampshire. But I feel that that is coming this way in the future. And I know that there's a lot of states that have programs for these folks, like my friend Gary. And he could, those programs could be implemented in this state also. I guess that's all I have to say. Other than if a prisoner has the guts to do this and get out of, and toe the line and get out of prison, this life we lead is not that great as it all seems. I drove through a whiteout snowstorm to get here, and it just it's hard to be, out here and doing what we do every day. I'm not saying prison life is easy, but it's a tough decision, and that's all I got to say. Thank you guys very much.
Thank you for coming.
All right.
The chair calls the Honorable Robert the Burge.
Okay. Thank you, Mr. Chairman and members of the committee. I'm going to be very, very brief. You have in front of you my written testimony. I've been in the House for 24 years. I know what it's like. I've chaired committees, and when you have a slew of pink cards, I can understand where the chairman would have some frustration. Just two things that I wanted to point out in my testimony. Out of respect for the sponsors of the bill, I would like you to disregard the criteria that I mentioned in one of the paragraphs that I have listed, only because I didn't want to disrupt or upset the bill before you. But so the second point I want to make is that I've known Gary, and you're going to hear other stories, so I don't have to reiterate that, but both Gary and I are Vietnam War veterans. I strongly believe that at the time that he was sentenced, if PTSD was known and the factors and how it relate, that his sentences would have been different. That's all I have, Mr. Chairman, out of respect for time.
Thank you, and I appreciate that. The chair calls Eric Reed.
Good morning, Mr. Chairman and committee. Thank you for having this meeting for us. I'm the nephew of Gary Place. I've been a supporter of his for 42 years now. 42 years ago, we lived one block behind us here on Spring Street. That's where Gary went right after he committed his crime. He explained to us what had happened and immediately turned himself into the Concord Police Station, took accountability for his actions immediately. And ever since then, I've had respect for him for that, plus his military service. Gary requested execution, but that was not an option. He was then offered a plea bargain for 18 years to life, and he refused that because he wanted to be punished for his crime. Again, taking accountability for his actions. That's basically how we were raised. Since then, we've, even as a child, as a 10-year-old child, we would visit Gary in prison consistently. To this day, I still speak with him weekly for at least an hour a week, every Wednesday evening, and have meaningful conversations about helping other people and what we both do to help other people. We're a lot alike in that way. There's a robust plan for Gary to continue his work. If he was released, we would work together, counseling veterans and anyone in need to help avoid incarceration and suicide, and basically to give people hope. And that's really where everything goes wrong, when people don't have hope, inside and outside. One of the questions that came up earlier is, what does someone that's been incarcerated this long do for support? I can tell you Gary's support system is as robust as his record in prison. He has over 200 pages of support, in either accomplishments or support from others, everywhere from his victim's sister to his prosecutor that put him there in the first place. So I think that's pretty remarkable. He paved the way with, in his trial, he was the first person in the nation to be to have the PTSD defense. And given the chance, he could be the first one to pave the way for others for successful reentry into the public. That's about all I have. Thank you.
Thank you. Thank you for sharing the story. Chair calls Andrew Valinsky.
Good morning, Chair. Good morning, members of the committee. My name's Andrew Valinsky. I live in East Concord. I come in support of HB 638. And I come not as a Democrat or as a former executive counselor, but as a citizen seeking mercy for this group of individuals. It's easy to show mercy to your friends or to those who committed minor crimes. This would stand out. It would show New Hampshire's commitment to justice. HB 638 creates a possibility of parole. This bill would not release anyone in and of itself. The chairman of the New Hampshire Parole Board is here. He will speak to you. There is an entire parole process that evaluates issues like recidivism, dangerousness, support on the outside. Questions could be answered like those asked by the vice chair. That is part of this process. Victims of crimes, their relatives maintain the right to participate in the parole hearings. This bill simply makes a person eligible to ask for a hearing. You've heard a lot about Gary Place. I think of him as the face of this bill. He is my client. He has a remarkable record at the Berlin facility. He's been locked up since the day of the crime. As his nephew mentioned, he turned himself in and essentially began serving a sentence at that time. He's taken advantage of every rehabilitative opportunity at the prison and has helped scores of others. As a former executive counselor, I want to mention the commutation process, which is what people would think of, takes care of people like Gary Place, who may be deserving of additional consideration. The commutation process is broken. It does not work. It's a political process. I was on the executive council when Gary Place applied for a commutation in 2018 under Governor Sununu. He also applied in 1999 under Governor Shaheen. He did not even get a hearing in either case. Councilor Joe Kenny and I voted for a hearing. The other three councilors denied Mr. Place even the opportunity to be heard. What this bill does is it gives people who qualify under the three parameters the opportunity to be heard by a non-political party, a non-political body, the parole board, who has experience in evaluating the questions that should be asked about people who've been in prison who've committed serious crimes. I've submitted written comments along these lines. I've excerpted the extensive materials submitted to the Executive Council in 2018 and in 1999. They're appended to my comments. I'm happy to answer questions if anyone has any, but I beg your consideration and recommendation of HB 638.
Thank you for your testimony.
Thank you all.
Chair calls Cynthia Mooson.
Good morning. My name is Cynthia Musso. I'm a staff attorney at the New England Innocence Project. I'm also a New Hampshire native. I live and work in Henniker, and I was a criminal defense attorney for years in the state before I came here. I say this all because I can tell you a couple of things. I just wanted to address a couple of questions. Representative Rhodes, you asked about the possibility for support when the person is released. I just want to mention that in the normal prison process, you're downgraded and stepped down through that process. But if you have a life without parole sentence, you don't go through that same process because there is no downgrading all the way to that community corrections level. But if you have some parole eligibility, the prison will start working with you at that point to develop a parole plan so that you have support, a job, and a place to go when you're released. So that's all things that will be in place, and that doesn't need to be contemplated by the bill because it is contemplated, as everybody has said, by the parole system. The New England Innocence Project goal is to increase fairness and justice in the criminal legal system, and we fight against wrongful convictions here. These innocence cases that we work on teach us how the criminal legal system fails. There have been 3,586 exonerations in this country since we started collecting that data in 1989, and over 200 of those were sentenced to life without parole. And what this tells us is that we're failing folks not only on the trial level with this wrongful conviction, but also compounding that failure by sentencing them to life without parole. And what we're also being told by this number is that there are likely innocent people that have died in prison serving a life without parole sentence, and that there are innocent folks incarcerated currently serving life without parole sentences, including in this state. These are death sentences, and they are directly impacting innocent folks. Life without parole sentences don't reduce crime. They do not help public safety. They disproportionately impact communities of color, and they cost taxpayers millions of dollars. When we talk about the goals of sentencing, one of them is preservation of public safety, and a lot of folks talk about the idea of life without parole sentences really holding up this public safety arm of sentencing. But what we know is that these prison sentences are not reducing crime, especially for these older folks. We've heard today that the numbers just don't support this. The reality is that like the percentage of folks that are going to recidivate when you get to over age 55 is pretty significantly low. It's the lowest of any age range that exists. We're not preserving any public safety by keeping these people incarcerated. They're also very expensive. It's very costly to house and care for folks that are incarcerated. It is proven to negatively impact physical and mental health. Life expectancy is reduced for 2 years for every year of incarceration that you undergo. A significant proportion of the folks that are on LWOP in New Hampshire are over the age of 55. And so we're spending all this money on these people that we could use and reinvest back into our communities without impacting public safety. The proposed bill doesn't, as everybody has already said, release folks out into the community. It gives merely a chance at parole. We in New Hampshire have evidenced this idea that we believe that just because there's a sentence, it needn't be a death sentence. There are other statutes that contemplate early release in this state. The only thing left I have to say is that the most important thing, as folks have said today, is hope. This bill provides that hope, and hope is often all that innocent folks have that keeps them holding on to fight for their freedom.
Thank you very much.
Thank you.
The chair calls Ophelia Burnett.
Good morning. So I just passed out some pamphlets for a reentry program that I'm launching. Good morning, Chairman and members of the committee. My name is Ophelia Burnett, Healing Justice Program Associate with American Friends Service Committee. I advocate for formerly and currently incarcerated individuals, and I'm also launching a reentry program for formerly incarcerated women coming home from incarceration. And it's also beautiful reentry. Thank you for this opportunity to testify today in support of HB 638, which would allow individuals age 60 and older to have served at least 20 years for the first-degree murder to be eligible for parole. This bill is not about excusing crime. It's about believing in second chances and improving our justice system. As a society, we must acknowledge that people do change. Take me, for instance. Some of you may or may not know that I myself have been justice impacted and did 4 years in the New Hampshire State Prison for Women. And I am not the mistake that I made 20 years ago, but I am here now sitting amongst all of you as the Healing Justice Program Associate advocating for formerly and incarcerated women. So I'm looking for proof. So I'm living proof here before you that people do change. And decades of incarceration, particularly for older individuals, changed them in a significant way. So the question is whether continued incarceration for this population serve justice, public safety, or physical gain. So let's talk about who this is really impacting. I always say that facilities are called departments of corrections, but our behavior is really being corrected. Society says incarcerating individuals make our community safe, but studies have shown that it does the complete opposite. Let's just touch base on mental health for a quick second. About 37% of people in prison have a history of mental health problems, according to a 2017 report, the U.S. Department of Justice. More than 24% have been previously diagnosed with major depressive disorder. Given the complexity of the reentry process, a person's health, both in and out of prison, likely affects their ability to avoid crime and follow parole rules after release. Many people leave prison without having their mental health issues recognized or treated. This often leaves them to reoffend, commit more serious crimes, and end up back in prison. Without support, they struggle to find honest work and push back into life of crime. So let's talk about the bill and who this really affects. 60-year-old individuals and older. Research shows that elderly individuals pose a significantly lower risk of recidivism, according to the studies of the U.S. Department of Justice. Recidivism rates drop sharply for those over 60, especially for those who served long sentences. I mean, let's think about it. We all have grandfathers, grandmothers. For me, my mother is 82. What kind of crime is she really going to commit at that age? So being in prison can take a significant toll on individuals. And I'm almost done. The Department of Corrections reported that it costs $78,000 to incarcerate one person per year. These funds can be allocated to community crime preventions, support services, and a program like the one that I'm starting. We should use that money to build programs and provide the services and support that these individuals need to be successful. So let's address the root causes of incarceration, break down barriers, challenges, stigmas, and create a more inclusive, compassionate, and stronger society. Everyone deserves a second chance to become valued members of their community. So again, I urge you, I urge you, Chairman and members of the committee, to support HB 638. Thank you.
Thank you so much for your testimony.
If anyone has any questions, I'd be more than welcome to answer them. If not, thank you.
I don't see any.
Okay,
Thank you.
thank you.
The chair calls Griselis Glenn.
Good morning. My name is Griselli. I am speaking in support of this bill. I wanted to highlight that we already have in our RSA 651A7 is pretty much what the same thing as this bill, except for it excludes first degree murder. So with this bill, it would just be incorporating and be it instead of separating a certain people who've committed who we would pretty much label them their crime and not giving them the same opportunity as everyone else gets. I also wanted to mention a demographic of people who are incarcerated that doesn't usually get brought up, and that's those that are wrongfully convicted. Experts estimate that there's between 6 to 15%, 15.4% of people that are wrongfully convicted, and given that approximately 2.3 million people are incarcerated, that means that 138,000 to 354,200 of those individuals may be wrongfully imprisoned at any given time. So this might also be a hope for those that have been wrongfully convicted, because let's just face it, our justice system has not always done right by people. I've experienced it myself personally. They've made a lot of mistakes. We're continuing to correct mistakes by coming up with different bills and trying to actually address the to address justice and actually have justice for everybody, because where I come from, we don't all get that justice, the same justice that you might see for somebody else. So, and I also wanted to highlight from our Constitution, Article 18, where it says that all penalties are to be proportionate to the nature of the offense. No wise legislature will affix the same punishment to the crimes of theft, forgery, and the like, which they do to those of murder and treason, where the same indistinguishing severity is exerted against all offenses. The people are led to forget the real distinction in the crimes themselves, and to commit the most flagrant with as little compunction as they do those of the lightest dye. For the same reason, a multitude of sanguinary laws is both impolitical and unjust. The true design of all punishments being to reform, not to exterminate mankind. And people who are given the opportunity to come out and spend life in there is exactly that, exterminating their existence. Thank you.
Thank you for your testimony. The chair calls Sarah Bonilla.
Good morning. Grand Rising Chairman and members of the committee. My name is Sarah Bonilla. I am on the leadership team of the Oh So Beautiful Reentry, the Women's Initiative. I want to say thank you for allowing me to speak in support of Bill HB 638. I want to say that I am formerly incarcerated individual, and there was a time in my life when I made pretty bad decisions. It took me years after my release to get my life together due to trauma that occurred prior and during my incarceration. I was worse off upon my release than I was upon my arrival to my incarceration, and had to seek out my own help. I am now a functioning, positive person in my community, and I help many others with several issues that stem from incarceration in general, but especially long-term. My mistakes did not define who I am today, almost 20 years later. Life without parole is a form of walking death, offering no hope for a future. Not only do they feel a sense of hopelessness, but their families and loved ones are punished with the same sentence, watching a loved one grow older and closer to death with no hope for a future. It takes away a person's right to rehabilitation, redemption, and reunification with their families. People do change. I am not who I was 20 years ago, and I believe it is the justice system's job to allow for this potential of rehabilitation and redemption. So I ask you, Chairman and members of the committee, to please support the bill HB 638. Thank you.
Thank you for your testimony. Is there anyone else wishing to testify on this bill who has not done so? Seeing none, I hereby close the public hearing. Next one. I hereby open the public hearing on House Bill 670, and I invite the prime sponsor to introduce their bill.
No, I'm just here in case there are any questions. All right.
You ready? Okay.
Well, good morning, Mr. Chairman and members of the committee. First time testifying in this committee. HB 670, well, let me start. Representative Len Turcott, I represent the towns of Barrington and Stratford, which is Stratford County District 4. The legislation that I brought forward was brought forward on behalf of a Rochester citizen who you will get to hear from shortly, Ms. Ann Berry. Ann will tell her stories. When I reached out for other co-sponsors, just reached out for a few, and each one of them actually had individuals within their own districts that had gone through a similar situation. I've also submitted a testimony of an individual who sent it in to me. I don't think he posted it on the website, but I put it there for you. And I've also given you a copy of the RSAs that actually this refers to, just for your, so you know what's going on. The bill itself, what we have done is increased the fines, or the, if you will, for nuisance dog attacks, bites, and different things. You'll see in the very first, on line 15 of the bill itself, they change from 25 to 100 and 100 from 200. I'm not sure when these were last updated, but I think $25, I think we could all agree, is probably in need of an updating. We did the same for line 18, bumped those up, and the very last one is really the one that is why we're here, and that was actually vicious attacks where, as you'll hear, Ann Berry's daughter was viciously attacked with thousands and thousands of dollars of damage to her, and you'll hear her story. Initially on line 24, I had bumped that to 2,000 until I got word from OLS, who said that's actually a felony charge, which I didn't realize. So that's at the 1,000. The other big thing that's added, what I think is a major improvement, is that the owner of the dog shall be liable for the medical bills. That wasn't the case prior to this amendment or the bill. As you'll hear again from Ann, the medical bills sustained were just astronomical, and that should be the responsible of the dog owner, not the individual who gets attacked. The final, where is it? Ah, there it is. The last part of it is on page 2 of the bill, and that's line 2, where we change the requirement for a municipal court proceeding after multiple attacks by the same vicious dogs. It goes from a may to a shall, and that's just so it doesn't give the courts the opportunity to bow out and go, well, you know, we're not going to handle that. We make that a shall. So, I mean, that's it in a nutshell. I think fairly simple. Be happy to answer any questions before you hear from Ms. Berry.
Thank you, Representative. Representative has a question.
Sure.
Thank you, Mr. Chair. Thank you for taking my question. I apologize, I don't have the text of the bill in front of me. I was just wondering, does this only apply to attacks on humans, or does it apply to attacks in general?
If you go to in the RSAs themselves, in the piece that I handed out to you, it kind of addresses that. Each of those different fine increases are for different types of dog nuisances. The big one is actually would be RSA 46631 and G, and that's where it says, if whether alone or in a pack with other dogs, it bites, attacks, preys on game animals, domestic animals, fowl, or the important one to me, human beings.
Okay, thank you. I'll have to look into that.
Representative Newell.
Thank you, Mr. Chair, and thank you for taking my question, Representative. I actually, it's interesting. I've had somebody reach out to me about the same type of situation, and tried to address it in a slightly different way, but I think approaching the same things that would be compatible.
Sure.
But what I wanted to ask in this one, and just for a little background, My door was broken, my side door was broken, and my dog figured out how to get out the door. It's like, you know, the dinosaurs learned how to do the handles kind of thing. Well, he figured out how to do that. And multiple times, actually, once while I was here, I got tracked down by, you know, the house staff here to say, your dog is, you know, he's been found and he's at the Humane Society. So because the fact that my door was broken, he was able to do this. And I was told by the police officer when they called that if it happened again, this is, you know, maybe twice or 3 times in the course of a month, that I would be charged $25 for a nuisance fee, which, you know, we had that conversation. The officer was very kind, and he said, of course, he didn't want to have to do that, but, you know, it was recurring. And obviously that, you know, paying that $25 wasn't going to help me get my door fixed, right? So which was the problem in the first place. So my question to you is, do you think...
I was wondering if that was coming.
Yep, it's great. I think it was all pertinent, though. Is your intention in raising the $25 fee for nuisance dogs to $100 to punish someone like me whose door is broken and who's, you know, being charged $100 now instead of 25 is not going to help to resolve the issue in the first place? I think that all was necessary.
Yeah, I can. That was a lot of comment, but I think there was a question in there. Yeah, what I would say is, yeah, I think each part of that raises the amount, I think, to give the owner of the dog a little bit more incentive to take better control of their dog. I don't know if that's a fair question, but yes, if your dog continually got out of a broken door, and the police said, hey, this is the 3rd time he's got out of your broken door, we're going to fine you now $100 versus $25. Yeah, that's the intent.
Can I follow up really quickly? It'll actually be really quickly.
At any point in this, did you fix your door?
Well,
Yeah.
we're working on it. Okay. And no, okay. Anyway, I'm not going to get into the side story there. Anyway, point being, is there any possibility of maybe keeping the rest of this and understanding that, of course, we don't want people to be in danger, and we don't want, you know, dogs who are menacing and things like that. That is a serious issue that I feel like it makes sense to raise the stakes for that. But for nuisance, particularly for nuisance, is there any chance of relaxing that part of your bill?
As of a few minutes ago, this bill is officially in your committee. You now have ownership of that, so any amendments that you would like to put on that would be up to you guys.
Okay, thank you.
Thank you.
Thank you.
Chair calls Ann Berry.
Good morning. First time here, so excited to learn about the experience as well. So as State Rep Turcott indicated, my name's Ann Berry from Rochester, and I am here in support of the bill as it stands today for bill number 670. So I'm in support of this because I will rewind us to Christmas morning in December 25th of 2023. My brother-in-law and sister were visiting us from Washington, D.C. for Christmas Day, and they brought their leash dog. I had my leash dog, and my daughter had her leash dog. We were going for a beautiful and nice Christmas morning walk before brunch and spending time with friends and family. So feeling like we were safe in a neighborhood that we choose to live in the city of Rochester in the state of New Hampshire. We were almost completed our walk, and out of nowhere, a 75-pound pit bull, what we learned later was a 75-pound pit bull. All I saw with my brother-in-law and daughter walking in front of me with their dogs, and my sister and myself with our leash dog, what we saw all of a sudden out of the corner of my eye is our daughter, my daughter, who was probably about 5'8", 190 pounds, being taken off her feet and to the ground. We didn't know what happened. We didn't know if it was a vehicle, a person, an animal. It happened so fast that she was brought to the ground. Immediately, we started panicking. she had a hold of her leashed dog, which is about a 50-pound sheepadoodle. And we started hearing screaming, not a noise from that pit bull that was unleashed coming from one of the neighbors that we live near. The attack went on for probably about 90 seconds to 2 minutes. And I ran to the closest home, to which I believed then when I realized it was a dog, and ran to a neighbor's home and pounded on their door for 25 to 30 seconds before someone would answer the door. The owner of that unleashed pit bull that was still attacking my daughter on the ground, she never got up, and her dog, that owner was finally able to get out of the home, come to the street side on Christmas morning, and finally get his pit bull unleashed, bloody, had a piece about this big pulled from my daughter's sheepadoodle. She's on the ground, covered in blood, feces. Her hand, we didn't know if it was a piece of her pinky missing or if it was hanging off her, blood all over the place. And she's a physician's assistant, so of course we were very worried that she's got a hand injury. Immediately, my husband heard he was at home preparing brunch for us on Christmas morning. He quickly jumped in the car, grabbed my daughter and the dog, and I have pictures that I'm happy to share after I'm finished. He had to drive very fast to Portsmouth Vet and drop the dog off, missing a piece down to muscle for her dog. Drop the dog off at Portsmouth City Vet in Portsmouth, New Hampshire, and then essentially drop the dog in the lobby and bring my daughter to Portsmouth emergency room. And my daughter, thankfully, the dog did have a rabies shot, and my daughter had lacerations, stitches, puncture wounds, PTSD from that dog attack, which was completely unnecessary. So so she recovered, I would say, probably within a month's period of time. She had just started a new job, so it was a hardship in regards to her telling a new employer as a physician's assistant that she would be out of work. It is in our neighborhood, so you can imagine we're never allowed to walk her dog in our neighborhood, and we do care for that dog quite often for her because she has other commitments. Her dog spent total, she was fully recovered, I will call it, in March of 2024. It was $20,000 to $25,000 that it cost. Her dog ended up getting some sort of pig valve implant to get this wound to heal because it's a dog tear. And we spent, it was $9,000 for my daughter's medical care. She's a physician's assistant, so she could care a lot for herself and knew what was going on. So it was about $25,000 to $30,000 for something that, as you can see, the fines are very, very small today. So that would be one piece of it. State Rep Turcott also talked about the owner being liable. The owner has not paid yet. So we have been out this money to pay for an emergency situation. This dog is a child to my daughter because she doesn't have children herself. So especially on the portions of the bill that talk about the owner being liable, we now have to incur additional days off, go to small claims court, and try to force this owner of this dog, who admits the dog was not in control, and we had to incur this on Christmas Day. So I'm here today, excuse me, on another day that I'm missing from work. My daughter has missed 2 days from work. I've missed 2 days because we're trying to just recoup money from small claims court, which that's a cap at $10,000. So $10,000 when you're talking 20 to 25, maybe even upwards of 30,000. We didn't count time off, gas, tolls, other accommodations we had to make for them to live with us over that period of time of recovery. During the court hearing, the gentleman that does own that unleashed pit bull, during that court hearing, we just had in December or January, has indicated the dog has done it again and the dog has been euthanized. And we said that from the start when we called the police, this dog needs to be euthanized. That is not a normal reaction. We all had leash dogs. It wasn't interrogated. It came from behind this person's house across the street, took my daughter again off her feet. And then that dog would have killed. It was seconds away from killing the dog or my daughter because she continued to roll on the ground with a 75-pound pit bull. So appreciate you letting me testify today in support of this bill. Again, I have pictures that I can leave with whomever as you consider the update to this bill, and I'm happy to answer any additional questions.
Thank you. If any of the members want to see the pictures, you can just ask her after I close the hearing. Any questions? Seeing none, thank you for your testimony and sharing your story with us.
Thank you.
Is there anyone else wishing to testify on this bill who hasn't done so? Hand the card in, please.
Thank you, Mr. Chairman, members of the committee. I'm Kurt Ehrenberg. I'm the New Hampshire State Director of the Humane Society of the United States. Thank you for the opportunity. I don't have a position either for or against this bill. The concern I heard from Representative Newell, I think, is a valid concern. There are many pet owners in New Hampshire who are low income, who love their animals as much as anyone, but find it very hard to afford everything. And as was said here, these are family members. And to keep the nuisance fine at $25 sounded to me like a heck of a good idea. Notwithstanding the other numbers in the bill. I would think that would be a consideration. First nuisance offense is not a big deal. As the representative said, it could be a small dog in a, with a door that's not working. Of course, you should have fixed it. But that is something that $100 for some families really could be a real problem, in a week where they're just trying to make ends meet. So that's, and there are a lot of obstacles to pet ownership for low-income people. It's expensive, but as we said, it's a member of the family, and, we try to make it as easy as possible for people to be in living situations with their pets. So thank you very much for listening to me.
Thank you for your testimony. You just want to talk to him, or do you have a question? You can talk if you want. Go ahead.
Question?
I feel like I need to be vindicated at this point. Would you believe that I actually also had a fire in my house right after this happened, so that is why my door is not fixed? I just want you to understand that I'm not living in the house and my dog is down in Massachusetts because we can't have him in
I'm
the
sorry
yard.
about that.
So okay, all right.
I feel like that was an appropriate use of, do you believe? Open the public hearing on House Bill 700 and invite the prime sponsor to introduce their bill. Who's 700? Is it me? Who's 700? 700. Representative Love? No. Okay.
Thank you, Mr. Chair. For the record, my name is Representative Kelly Potenza, Stratford District 19, Rochester Wards 1, 2, 3, 4, and 6. I'm here today to make some fixes to something that I discovered because, I was a recipient of one of these orders. I just passed out to you all a copy of what someone fills out for a stalking petition. The first part of my bill which is really important, is to make sure that when someone goes into the court and files this, especially if they're doing it in a retaliation mode, and not based upon any evidence and facts, that they know that they're going to be liable to have a felony perjury on their record. So that's the one piece of the bill. And the second piece of the bill goes on to page 2 of the handout that I gave you. So I'm just going to give you the scenario. An assault happened to a member of my family, and before that person was arrested, they were in chats and saying horrible things. They knew my family member, where they went to school. They knew their phone number, had their email address. This was a good friend of the family. So the police advised us to file this protective order. Now, this isn't something that we were familiar with, of course. So we did. It was after court hours, so we did it at the police station. And we checked off on that page 2, boxes number 1, number 2, number 4, and number 15. And the only reason why we did this was because the person hadn't been arrested yet. And we knew that once they were arrested, from hearing this, of course, from the police, that they would have bail conditions, meaning no contact with our family. And so we did this in place. Unbeknownst and unknown to us, once this was filed, and then it went to the other police department for it to be enacted, they went to the person's home and they confiscated all of their weapons. That made that individual extremely angry. We didn't want his weapons taken. All we wanted to make sure was that there was no contact at all, that he wasn't anywhere near our family. And how were we supposed to know that? Of course, you see on here, right? Number 6 box check is to take weapons. And so this all goes down, and then within, because it was on a weekend, then within 2 days, because he filed in the court on Monday, on Tuesday, we have the Rochester police come and knock on our door, and we've got a protective order, once against me and once against my husband. And every box he checked off, saying that, he fears for the safety of, himself and his family. All lies throughout the whole thing. It was awful. My daughter, mind you, the one that took out the protective order, was so freaked out because she thought we were going to get arrested. She fell down the stairs. I mean, it was the worst situation ever. Of course, we went to court within 30 days because that's how this works. The person failed to show up. It's immediately dismissed. But then we still have to go through the process to get another hearing to go get our firearms back, all because of a retaliation. I have talked to 10 different police officers in Rochester. I've talked to 4 different police officers in Coos County. I have talked to 5 different police officers in Hooksett, and this is a common thing. So I want this in place. I want someone that is, a domestic abuse situation, if there is, of course, if there is any sort of stalking situation, ex-boyfriend, ex-girlfriend, whatever it may be. You need to have these in place, of course, and firearms should be taken if you're fearing for your life. That makes sense. And I understand where due process doesn't really, kind of fly in the sense of taking somebody's firearms if there is an imminent threat. I understand all of that. But we didn't say that there was a threat in the sense of that we feared for safety of that he was going to, grab a firearm and do something. And so with this whole thing that happened, we just realized a gap. But every single one of these police officers said how common this is. So someone takes out, we don't call it a restraining order. I mean, this is what we were told to fill out, because there wasn't a perfect pathway. So we thought that this was the way because we checked off box 1, 2, 4, and 15, but it didn't matter. Once you fill out one of these, all of the weapons are confiscated, no matter what box that you check off. And so this is used all the time in a retaliation effort. And just talking with the police officers in Rochester that came to our house not once but twice, because they served my husband first and then me, they said it's just a gap in it's a gap and a loophole in the system, and I'm trying to fix that gap. I'm happy to answer any questions. That's where I'm at.
Thank you. I'm just now looking at the language. Does your bill then make it so that firearms are not taken unless it's requested? Is that the gist of it?
Pretty much.
Are you aware of federal law that says that any protective order requires all firearms to be confiscated?
I am, but we don't have another, then there should be another form that's built then, because you've incorporated it all into, in a sense, into one. So there was no other form that we could have filled out that was no contact with our family, like a restraining order type of piece. There's a no trespass, but that doesn't work either, because you'd have to put that no trespass at our home, at her school. It just didn't work. So this was what we were told to do, but we were never told that it would go, they would go relinquish all his firearms.
Yeah. I think the problem is that it's a federal law that if there's any protective order in place, you can't have firearms. So even if we change this, I'm not sure that it will change the fact that they still can't have the firearms because of the federal law. But I'll look at it and see if there's anywhere in between there. Any questions for the sponsor? Seeing none, thank you. Rep Love.
Thank you, Mr. Chairman. Thank you, members of the Criminal Justice Committee. My name is Representative David Love. I represent Derry, Rockingham 13, and I've got a couple short stories to tell you what's happened to me with similar stuff here. 20 years ago, my ex-wife, took out a restraining order on me, and a weaponized restraining order. None of it was true. And when we went to court, 5 days later, My attorney went up to her and her attorney and said, look, we can prove that you're lying here, and you have signed a perjury statement at the bottom here, and we will push for perjury charges. So I suggest you drop it now, and she did. Okay, it took me time to get my guns back and all that, but about 12 years ago, I was this friend of mine, or what I thought was a friend of mine, knocked at my door, and we were having a hurricane the next, that afternoon or whatever, and he had a Jeep with a rag top on it, and he was having a hard time putting it on. He wasn't very well, and he asked me if I'd help him put it on. So I helped him put it on, and the hurricane came and it blew the rag top off the top of his Jeep. And then he came to me and said, you owe me $800. So I did what a lot of people do. I laughed at him. He went to the Derry court. He filled out a restraining order, and it started out with, Mr. Love wants to overtake the United States government. He owns many guns, things like this. I mean, it was bizarre. Okay, and there was no perjury statement at the bottom of that restraining order. And, I went to court once again, and I had brought two people with me that, were down at the clerk's office when he was handing in the papers. And he turned around and he said, good, I just got his guns taken away and it's almost hunting season. Okay? People do weaponize these things, use them for things that they're not intended for. But anyway, I won that and, got my guns back. But, the fact of the matter is, some people need these, to stay alive. And when somebody lies, it kind of minimizes what a restraining order is, in the public perception. Terry got a restraining order, big deal. His wife's probably lying anyway, is what the people walk around. I take them very serious. When I hear somebody that has weaponized a restraining order, I get pretty mad. But it's because it's happened to me, but also because it's, there could be people behind me that have needed restraining orders to stay alive. And, this has got to stop, and unless we have them signing perjury statements and the court, we have to have civil courts too, to enforce them, because they don't, is what the problem I've heard, and, I think this is a good idea. It's got a couple little flaws that, you guys, it's your bill now. You can amend it to fix them. And, but let's make lying a crime. When you're going to mess up somebody's life like that, make a lie a crime. If somebody's opposed to this and that's the only thing, well, don't lie. It's as simple as that. Thanks.
Thank you, Representative. Anyone else? Oh, Representative has a question for you. Representative Scher.
Thank you, Mr. Chair. I'm looking at the stalking petition that the prior witness provided us, and at the very end, it says, I swear the foregoing is true and correct to the best of my knowledge. I understand that making a false statement on this petition will subject me to criminal penalties. Is that statement not on?
The one that, thank you for give me that question. The one that I had 10, 12 years ago during that the last restraining order on me, did not have it.
Are you aware that to charge somebody with perjury for a sworn statement, there doesn't need to have been a perjury statement, as you describe it, on there? They can still be charged with perjury? You aware of that?
They should be, but it's not being done.
Thank you.
Representative.
Question. Thank you, Chairman Roy, and thank you for taking my question, sir. Are restraining orders, as they stand now, not automatically reciprocal?
I'm not sure
So if reciprocity, so if I request for a restraining order on someone, there's automatically an order of protection. It would be back on me where I can't. So there's not. Okay. Thank you.
Yeah, they're only one way.
Mm-hmm.
Thank you. Chair calls Pamela Kovic.
That it? No more questions?
Good morning, Mr. Chair and members of the committee. My name is Pamela Keilig, and I'm the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. As you know, the coalition is the umbrella organization for our 12 community-based crisis centers who provide free and confidential services to nearly 15,000 survivors of sexual and domestic violence annually, and that includes survivors of stalking. I'm joined today by Shauna Foster, the executive director from one of our member programs, New Beginnings. We are here in strong opposition to HB 700, which will make it harder for judges to remove deadly weapons from dangerous stalkers. We understand what the sponsor is trying to address, but there are unintended consequences to this bill. We shouldn't put the onus on the victim to check the box. In practice, it's automatically done because of a high rate of lethality in these cases. This isn't a loophole. It's very deliberate and geared at protecting people from further abuse. So I'm going to turn it over to Shauna, and then I'll speak a little bit at the end. But thank you so much for hearing us today.
For the record, my name is Shauna Foster, and I'm the Executive Director of New Beginnings Without Violence and Abuse. We are the crisis center located in Laconia and serving all of Belknap County. As someone who has worked alongside and supported survivors for over a decade, I have significant concerns about the impact of this bill and how it would affect victims of stalking. In 2024, New Beginnings advocates provided 163 services to 50 stalking victims, including 30 court accompaniments. These accompaniments typically involve assisting the victim with filing a stalking order of protection, discussing the judicial process and victims' rights, and accompanying the victim to the final hearing for their order of protection. Last year, a New Beginnings advocate responded to court to help a victim file for a stalking order of protection against a neighbor. This neighbor had been stalking and harassing the victim. The morning that she presented at court, the neighbor had pulled a gun on her during an altercation related to the stalking. Many victims feel confused and overwhelmed by the process, and this bill creates additional barriers. Asking victims to attest to their truthfulness not only adds to their shame and self-blame experienced by many stalking victims, but what message does it send to victims about who should and should not be believed? Why are we adding this language to this particular offense and not to offenses like burglary? It's also likely to discourage victims from seeking essential relief. Victims should not be afraid of potential legal consequences when they are already in fear for their lives. This provision is also unnecessary. Stalking petitions already include a section requiring victims to swear that the information they provided is true and accurate, and that they could face penalties if anything submitted is found to be false. We've attached a copy of a stalking petition to this testimony. Additionally, it would place victims in harm's way by changing the criteria to remove an offender's firearms. The relationship between an offender of stalking and their victim is not an appropriate measure to determine whether a case may escalate to lethal violence. Judicial discretion is critical when assessing the level of danger of a case and the need to remove firearms from an offender in order to protect the victim from further abuse. Stalking is a serious crime that can uproot a victim's entire life. Advocates at New Beginnings and across the state work tirelessly to support victims as they navigate the very scary and dangerous experience of being stalked. Survivors go to great lengths to seek help and remove themselves from the people who cause them harm, whether that be relocating to another town, county, or even out of their state. As a result of being stalked, victims often lose their employment, their housing, or other areas of support in their lives. They may have to change their phone numbers, email addresses, and social media accounts to prevent the stalker from engaging with them. And even then, stalkers may still find them using new tactics to continue the abuse. Bills like HB 700 go against everything we know as advocates about stalking and the very real experiences of victims in New Hampshire. We should be doing everything we can as a state to stop abuse, not creating new pathways for harm. Victims deserve to feel safe and to have peace of mind. They do not need another reason to keep looking over their shoulders for the rest of their lives.
Just in conclusion, I think just to reiterate, the incessant and unpredictable nature of stalking causes victims to remain in a constant state of hypervigilance and terror. And this can also have severe long-term impacts on their health and well-being. All forms of stalking are dangerous, whether the person is a neighbor, an old acquaintance, a dating partner, or a stranger. Stalking is a serious and potentially lethal crime, and it should be treated as such.
We ask the committee to please consider voting no on HB 700 and ensuring victims that they're not alone. Thank you so much.
Representative Scheer.
I just need to clear up some language in my ignorance. We've heard the term stalking petition and then restraining order, and if not in this hearing, we've heard about protection orders. Are those three different?
Sure. We are using the language interchangeably for these purposes. There are domestic violence orders of protection that require an intimate relationship between the parties. Stalking orders of protection have different criteria for the nature of the relationship.
Do each of the petitions that are required, whichever they are and whatever their names are, do they all have this statement where the individual swears to the truth of what they're saying, subject to criminal penalties?
Yes. Yes,
Thank
they
you.
do.
In an order for stalking, it goes the same way as it does for a protective order in domestic violence. In other words, the person served, if the petitioner doesn't check off the firearms, do the police confiscate the firearms anyway?
Yes. So even if I think the judge has discretion, and so, or do you want to answer that better?
Right. So they
Yeah.
go to the police, they fill out the form, the police bring it to the judge if it's a weekend, or they go to court themselves. The judge then decides whether to check it off. He has discretion. And then within how many days is usually the follow-up hearing where the person gets to actually go in and rebut this?
It is supposed to be scheduled within 30 days, and the defendant has a right to expedite the hearing. And in those cases, it will take place within 5 business days.
Okay, so within 5 business days, if the defendant goes in and asks for it to be expedited, at that point, he or she can petition the judge to have their firearms returned. Is that
Yes.
correct? Okay, thank you. Further questions? Yes, Representative Muse.
Could you let me know who actually fills out the form? Is it the victim or the police officer?
The victim, if it's after hours, the police officer is filling out the form using the victim's language, and that's submitted to the judge. During court hours, the victim is filling out the petition directly.
Follow up? What kind of, I'm thinking about the testimony of the sponsor and, just how hard an experience that is, for the victims as well. The whole process of, take me through how this actually works a little bit. How do we actually get to a point where we have a filled out protective order? And I think it's something we all like to think we understand, but it would just be helpful for me if you could just walk me through what basically what happens, when someone comes to the police station.
Sure. So in my experience, if this is happening after hours, the victim is working directly with the law enforcement officer. And if they have met the criteria for a stalking order, the police officer again fills it out, calls the on-call judge, and they are issuing a telephonic order of protection that is good until 4 p.m. on the next court day. Other avenues the victims may end up at court is either presenting on their own if they know that this is a tool accessible to them, or certainly by calling New Beginnings or one of the other 12 member program crisis centers. If they describe what they're experiencing, a trained advocate can inform them that this is a tool that may enhance their safety, and we can accompany them to court to answer their questions and help talk them through the process. So they then fill the document out on their own and go to the court clerk, and that's when they're swearing that their testimony is truthful.
You said that the order is good until 4 o'clock on the next court day. So at that point, the plaintiff has to go in and actually swear it in court to get the order. Is that ex parte, or does the defendant get to be at that hearing or not?
That part is ex parte.
Okay. So then the defendant gets served a second time once that new order's, and that's good for up to 30 days. Is that?
That's correct.
All right. Thank you. See nothing further. Thank you for your testimony.
Thank you very much.
The chair calls Shauna von der Linde.
Good morning. Thank you for hearing me today. This is my first time testifying and speaking about my experience publicly, so I appreciate it. My name is Shauna van der Linde, and I'm here to oppose HB 700. 8 years ago, my family, in particular my parents, were the victims of stalking and harassment from our then neighbor. The events initially started with targeted insults, accusations regarding property, and then escalated into a situation where her dogs were let loose, attacking our dog and biting my father. My parents obtained a stalking order of protection, but due to continued unwarranted harassment and increasingly fear-inducing behavior, my parents made plans to move from the house they had lived in for 21 years. Around 3 months prior to my family moving away from this person forever, she saw them pass by her house to take our dog for a walk. She then got into her car, purposefully hunted them, and ran all of them down with her truck. Then she drove home, leaving my family's bodies in the street. My father, Stephen, was thrown 30 feet and killed instantly from massive head and chest trauma. Our dog, Lucy, suffered multiple spinal injuries and had to be euthanized. My mother, Erin, was thrown 25 feet, suffering multi-system trauma, including multi-organ injuries and skeletal fractures, including every rib on one side of her body. After over 30 days in the ICU neurotrauma units and weeks at a rehab center, she still lives with the physical repercussions of that. She and the rest of my family continue to deal with the mental and emotional aftermath of that life-shattering event. And that's why I'm here today, to oppose this insulting bill proposal, because it sends the message that victims of stalking are any less credible than victims of any other crime. What is it about this statute that requires language reminding petitioners of the penalty for lying? Is this designed to be an impediment to victims speaking up for their right to feel and to be safe because they may not be believed? That is unacceptable. This bill presumes that victims who are being stalked by a neighbor or a stranger are in any less danger than those who are being stalked by an ex-partner or a relative, when that is clearly not true. My family's trauma should remind you that we should always assume that stalkers are, in fact, extremely dangerous. If a judge has determined that there are grounds to issue a protective order, they should always order the relinquishment of a firearm. Because our story shows that when a stalker decides to become violent, they will go to any extreme and even kill. The legislature has a responsibility to protect citizens in our state, and we cannot afford to weaken state laws and enable violent perpetrators to commit lethal crimes. So thank you again for allowing me the opportunity to speak today.
Thank you for sharing your story with us. Did that happen in New Hampshire?
Yes,
Thank,
and Seabrook.
okay, thank you. No further questions. Thank you.
Thank you.
The chair calls Attorney Enders.
Good afternoon. My name is Stephen Enders. I'm an assistant county attorney in Merrimack County. I've been a prosecutor for over 20 years. I do oppose this bill, and as the sponsor said, it has two distinct sections. The first section is including the language about false statements being made on the petition may be prosecuted for perjury. It's fairly unusual language in the state. Normally the language is that that false allegations shall be subject to criminal penalties, which goes beyond perjury, includes unsworn falsification, possible false report to law enforcement. As Attorney Scher pointed out, that language does in fact appear on the stalking petition as it's now written, and that is required by law. Under the stalking statute, it indicates that the process to be followed and the forms mirror RSA 173B, which is the civil protective order. 173B3 paragraph 1 says any person filing a petition containing false allegations of abuse shall be subject to criminal penalties. And subsection 4 of that paragraph indicates that the circuit court shall supply forms and petitions. All of those forms must say, I swear that the foregoing information is true and correct to the best of my knowledge. I understand that making a false statement on this petition will subject me to criminal penalties. So I think with reference to the first part of this bill, that language already exists. It's already there. With reference to the second part, which is the taking of firearms, under the stalking statute, it is discretionary within the court of whether or not they order the relinquishment of firearms. You had asked about federal law, and I think the federal law you're thinking of is 18 USC 922G, and specifically subsection 8 makes it so that a person cannot have firearms who's subject to a court order that was issued after a hearing in which you had an opportunity to participate, restrains the person from harassing, stalking, or threatening an intimate partner of such person or child. So if there's an intimate partner relationship, it does fall under federal law. So normally when someone goes to get an order from the court, an order of protection, one of the first questions they ask is, who is this against? If it's against an intimate partner, they're encouraged to get an order under 173B, which then has that sort of automatic provision under federal law. Stalking petitions are more intended for stranger situations where people aren't necessarily in an intimate relationship. And because there is no intimate relationship, it's really up to the judge's discretion of whether or not to order the relinquishment of firearms. It doesn't make sense to me that the judge would have to or be restrained from relinquishing firearms unless the box was checked. Certainly, we have intelligent judges in this state that can use their own discretion and decide when the relinquishment of firearms is appropriate. And I think what you'll find is in the vast majority of stalking cases, judges are going to order the relinquishment of firearms because stalking is a really scary crime. And as you heard from the person speaking before me, these stalking orders really are the first step in what's potentially intervention in a murder. So I think most judges are going to look at this and say, this is a serious thing, therefore we're going to order the relinquishment of firearms. But as it stands right now, judges have complete discretion on whether or not they do that. And I don't think that discretion should be limited based on whether or not a box is checked on the petition. I'm certainly happy to answer any questions.
The current state of the law in New Hampshire is either a sworn or unsworn statement giving falsifying it is currently a crime, regardless of whether you say, I swear not to or not, correct?
There doesn't need to be a warning in order for that to be charged, yes.
No kind of jurat necessary. And have you ever seen a case where firearms, once the, not at the ex parte hearing, but at the hearing where the defendant is present with the counsel, where firearms were returned?
Not if the stalking order is issued. I'm not.
Well, that's, I guess I should
Right.
have just asked at that second hearing when the stalking order was canceled or
So-
overruled.
Right. Normally, if the stalking order is overruled, I think you have to file a motion for return of firearms. You could certainly do it at that hearing.
Yeah.
I've never attended one of those hearings, so I'm not sure how common it is to do it at the hearing.
Okay, thank you. All right, thanks.
Thank you.
Anyone else wish to testify on this bill who hasn't done so? One question, yeah.
Thank you, Mr. Chair. I know that that statement was there. Basically, I was just hoping that it could be, I understand that making a false statement on this petition will subject me to criminal penalties. I mean, wouldn't it be nice to have it say under, pursuant to RSA 641(1) or what the laws are there? I just feel as if it should be, it should be more prevalent, and because the retaliation piece was huge. I mean, the whole statement was,
Okay.
these pages of pages where you can write whatever you want. And they were all, you know, it was all lies. And so, and of course it was an immediate retaliation. I understand. I don't want to get involved at all in any of the domestic violence piece, and I understand that. But they have their own petitions, and that's why I picked it on this one, because we were told to fill this out. And also the other question about the police department. My daughter was there at the police department, and because it was after hours, she filled it out. And then the police filled out something, but we were there and it was filled out in person. And that was an emergency order, and it went exactly like what you said until Monday at 4 p.m. And then when we went to court, the person had already been arrested and had bail conditions. So we immediately dropped the protective order. But there was no, her statement that night in the police department said, I just want to make sure, you know, because of the stuff that's happening, I had my interview with the child advocate, and I want to make sure that he can't contact me. That was what she wrote. And so we had no idea that the firearms would be taken. The firearms being taken is what made this person go ballistic.
Gotcha.
So.
Thank you. There be no one else, I hereby close the public hearing. We will be in recess till 1 o'clock.
Good afternoon, everybody. Hope you all enjoyed your lunch. It is 1 o'clock. We are going to open the public hearing for House Bill, is it 777?
777.
For House Bill 777. And we introduce the prime sponsor, introduces legislation.
Thank you, Madam Chairman. For the record, Representative Terry Roy, Rockingham 32. I'm introducing this bill actually on behalf of the commission itself. The New Hampshire Law Enforcement Accreditation Commission was established by Governor Sununu by executive order 2 years ago, and we just got it up and running, and we've accredited our first group of police departments after having gone through a long process of establishing what was required to achieve accreditation, and it's rolling along great. But what we want to do now is we want to put it into statute instead of just have it on the executive order. And really, that's it. We're just trying to formalize and finalize it. Director Skipper, who's also on the commission with me, is here to answer some questions, but I'll take any if you have any right now.
Representative Scheer.
I can't pass up this opportunity.
I didn't think you would.
How have you set up how the state accreditation, intersects with CALIA accreditation?
Thank you. We really don't intersect except for I believe we accept CALIA accreditation towards New Hampshire accreditation, but it doesn't necessarily take the place of it. You still have to meet the minimum New Hampshire standards if they are higher than CALIA. And Director Skippo knows more about that than I do, but I think that's the way it is.
Thank you.
Anybody, any more questions? Seeing none, thank you very
Thank
much. Skipper.
Thank you. Thank you, Madam Chair. For the record, John Skippa, Director of New Hampshire Police Standards and Training. I am here today to speak in favor of this legislation to codify the New Hampshire Law Enforcement Accreditation Commission. As Representative Roy spoke to, this has been an initiative with New Hampshire law enforcement over the last 2 years. The commission has worked very, very diligently in establishing accreditation standards, working with regard to providing training for assessment and program managers for accreditation. And in fact, we have had a number of mock and actual assessments for agencies to become accredited. The first agency was last week, and that is the Derry Police Department just received their accreditation. And we felt that it was important to codify this commission that was initially established by executive order of Governor Sununu. I stand ready to answer any questions.
Director, Representative Scheer.
Same question I posed to Representative Roy.
Thank you, Representative Scheer. In fact, the commission is working diligently to establish what we would refer to as a bridging document. That bridging document will take the CALIA standards, which is a nationally recognized accreditation program that New Hampshire agencies have access to. And in fact, we have a number of agencies, to include the Portsmouth Police Department, that is a nationally accredited agency. But we want to make sure that we can work kind of hand in glove to establish a bridging document so that those that have gone through the national accreditation can easily reach and attain state level accreditation, and then vice versa. You know, one of the other initiatives is to make sure that, particularly for smaller agencies that may not have those types of resources, let's get them state accredited with the hope that that would provide them enough impetus to move to a national accreditation.
Thank you. I know Portsmouth, having been through the CALIA process, it's a long, expensive, and valuable process, yes, but long and expensive.
Any further questions? Seeing none, thank you, Director Skipper.
Thank you, Mr. Chair. Thank you, Council.
Anyone else wishing to testify on this bill who has not done so? Seeing none, I hereby close the public hearing. Huh? I did. Yeah. Linda. I hereby open the executive session on House Bill, what is it, 777, and I make a motion of ought to pass.
Second.
Quick discussion. As I said, this was formed by Governor Sununu so that New Hampshire would have our own accreditation standards for our police departments. And there is a national, we heard about CALEA, which nationally sets standards for police departments around the country. And it is a very in-depth process where they come out and they look at all the things police departments are supposed to have to keep them professionally accredited. We felt, and Governor Sununu felt that New Hampshire was unique in and of itself with our different laws, so that it would benefit us as a local state to be able to have local accreditation as well. So he established this, and as you heard the director talk, we're trying to merge them so that people don't have to, departments don't have to have that big expense. But New Hampshire does have its own set of laws, so it's important that we have a few different standards that we add as well. So this is a really good thing to keep our police departments at the highest standards possible, the highest level of professionalism. So I would ask that everyone support it. Would you like to speak to your second?
Well said, Mr. Chairman.
Thank you. Any further discussion or questions?
Yes, Chairman Roy, thank you for your question. I noticed that there is no fiscal note whatsoever on this. This does not appear to cost anything to do.
Yeah, it's fund. I believe there were some initial funding from the general fund when the governor set it up, but now it runs off of grants from the federal government and the monies that the departments actually pay. Yep. Seeing no further, I'll ask the clerk to call the roll. The motion on the floor is ought to pass.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative DeSimone, Representative DeVoid,
Yes.
Representative Bogert,
Yes.
Representative Paquette,
Yes.
Representative Sabor Deschwanier,
Yes.
Representative Matson,
Yes.
Representative Harriet Gathright, Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Scheer,
Yes.
Chairman Roy,
Chair votes yes.
16-0.
16-0 passes unanimously. Any objection to consent? Seeing none, it will go on consent. What else we got?
I didn't recognize you. You look too formal. Hey, on your bill, did Solomon
Do you need the bill?
No. Did you open?
Welcome back, everybody. I'm going to open the public hearing for House Bill 778 and we'll invite the prime sponsor to tell us about his legislation.
Thank you, Representative Roy again, Rockingham 32. This is a bill that would allow the police officers that work at our law enforcement training center to be able to work details. Currently, it's a sacrifice for them to work there to train police officers because they can't legally work details. So they can't make the same money as a regular police officer. And we would like to encourage our best to go and train our newest. So to ask them to do so at a pay cut, I don't think is fair. So that's what this bill would allow them to do. And I understand we may have to make a quick amendment to it that would make sure that they can only do details if they're requested by a police department, because there may or may not be some interagency jealousy worried about somebody taking details from somebody else. So, but other than that, that's the gist of the bill. Questions?
Representative Prue?
Why can't they take details?
Because they're not statutorily allowed to. I guess the way the statutes are written.
Somewhere?
No, because they don't work for, I don't believe they work for a town, they work for the state. So if they're sworn law enforcement officers, in other words, let's say I leave whatever department and take a job for the state at the training center, I'm still a law enforcement officer, but I can't work details because I don't work for a department.
Sounds dumb to me.
And if I'm wrong, he's going to correct me, and that's fine. Yeah.
Representative DeSimone?
Thank you, Madam Chair. Thank you for taking my question. I'm a little perplexed about that because if I'm the chief of police in town A and none of my officers are available for a detail, I can call a police officer from town B, C, D, whatever. I
Yeah.
can't currently call from the state.
No, not
I
from
can
the,
call from the sheriff's department, but I can't call from the state.
that's correct. You can't call them,
Thank you.
but if we pass this, you can.
Thank you.
Anything else?
Anybody else? Seeing none, thank you very much. Director Skippa, welcome back.
Thank you, Madam Chair. Once again, thank you for your time, members. For the record, my name is John Skippa. I'm the Director of New Hampshire Police Standards and Training. I'm here today to testify in favor of this bill, and would maybe just like to add a little bit to what Representative Roy brought to your attention. We really see this as kind of a two-pronged effort. In the first instance, and rightly so, as outlined by Representative Roy, I am literally drawing talent from the same pool of police officers that every other police agency in the state of New Hampshire is also pulling from. And so from a recruitment and retention position, as the manager of an executive branch agency that employs police officers, I have to make sure that I can provide an opportunity for my police employees to not lose out on a benefit that they would have while working at one of the local or state agencies. Everybody who works for me presently as a police officer is a trainer, and they, in essence, gave up their opportunity to work details by coming to work at Police Standards and Training. And that's only because there's no legal mechanism for me to invoice another local agency. It's just not in our law right now. And that's really, the impetus for moving this forward, is so that we can just establish within RSA 106L the authority of the council to set a detail rate, and for me to actually be able to invoice towns. It's almost kind of a technicality. Secondly, and to Representative DeSimone's question and point, we routinely get calls from local agencies that are attempting to fill details or to get help. I can tell you that during the summer, I would routinely get phone calls from Chief Alex Reno from the Hampton Police Department. hey, we're expecting about 100,000 people here for fireworks, and I don't have enough police officers. Can you send me some help? My people are ready to do it, but I had no way to be able to bill the Hampton Police Department for those services. We get called routinely from the Loudoun Police Department when they have the races. Again, they need security details, they need traffic details. We are experiencing, as you all know, a real problem with recruitment and retention of police officers across the state. And so a lot of these agencies just don't have the resources to be able to handle these types of large events without getting help from other agencies. And so really, you know, thank you, Representative Roy, for sponsoring this, but this, if it passes, would give us the mechanism to be able to invoice those people that are requesting these services. I would ask that in line 3, and I'm no wordsmith, so I would certainly defer to all of you here, and this was at the request of the New Hampshire Chiefs of Police Association, to insert the following language after the word may. I would suggest at the request of the state, county, or local law enforcement agency of jurisdiction. And that is really just to make sure that obviously the local police chiefs, the county sheriffs, and those state law enforcement agencies, we would only be responding to their request. We would not unilaterally just detail officers to something. We would wait for a request for help from whoever was in charge of that jurisdiction, and then we would provide the services as we could. I thank you, and I stand ready for any questions.
Representative Rhodes.
Thank you, Mr. Chairman. Thank you for taking my question, Skippa. Could you tell me, are the officers that are doing this training, are they still like accredited police officers?
Thank you for the question. In fact, myself and all of the other trainers are full-time certified police officers, and statutorily we have law enforcement authority throughout the state. We really just don't have a mechanism to bill, to invoice those other agencies, and that's really what this legislation would help address.
Representative
Yes,
Bogart.
thank you, Mr. Chairman, and thank you for taking my question. If these officers are allowed to do a detail, what vehicle would they be using if they're using one that requires a vehicle?
Thank you for that question, sir. We do have a fleet of vehicles, predominantly from my position. I don't know that I would detail the officer with a vehicle per se. It would probably that I would just have them drive their own vehicle to the location. I'll give you an example. At Hampton Beach during the fireworks, they'll want officers on a walking beat really at every block along Route A1A. And so those officers would just drive their own car to the Hampton Police Department, and then they would get detailed out to their post. There may be times where there might be a request for a vehicle to be part of that detail. And just my experience as a local police chief, I understand that we would need to build in a rate of compensation to cover the cost of that use of that vehicle. And we would discuss that and ultimately let the council decide on what that number would be. Thank you, sir.
Representative Newman.
If this law passes and you have to set up those kind of details, do you have to make any other statutory changes, or can that all be accomplished just with this bill?
Thank you for that question, sir. It is my understanding, after doing a lot of research, that this is really the only change in legislation that would be needed for us to move forward and provide that assistance at request.
Thank you.
Seeing nothing else? Thank you.
Thank you.
Anyone else wishing to testify on this bill who has not done so? Seeing none, I hereby close the public hearing. What's everybody think? You want to exec this for him? He's been sitting here for hours. No. Oh, it does. It needs an amendment, doesn't it? Yeah. Okay. We were going to exec it for you, but no. Next week. Could you just, not right now, but when you get back to the station, can you email me that language just to make sure we got it right? What I have is, may, at the request of state, county, or local law enforcement agency of jurisdiction, I hereby open the the public hearing on House Bill 767 and invite the sponsor to introduce this bill.
Good afternoon, Mr. Chairman and members of the Criminal Justice Committee. For the record, my name is Representative Dave Love. I represent Derry, which is Rockingham 13. I put this bill together mainly that doesn't take a genius to figure out. It's got a lot to do with Harmony Montgomery and other children who died. While being having open cases or even closed cases with DCYF. DCYF has a lot of good social workers, and that's what they're trained in social work. And somewhere along the line, we gave them the responsibility of investigating crimes. We've got we've got children that are being punched in the face. Children are being sexually molested, and DCYF is investigating. They don't have any investigative experience or training. They can't get a warrant. A lot of times, if people have been down that road with DCYF enough, they get laughed at or intimidated. I imagine Adam Montgomery probably intimidated a few workers. He was a big, burly, nasty guy. And if you send a 23-year-old recent college student to his house, I imagine he's going to threaten and, I know where you live and that type of stuff. But if it was a police officer that knocked on the door, it'd be a whole lot different. And to me, it doesn't take a crystal ball to figure out that some kids would be alive today if police were investigating crimes. I was on the committee to investigate DCYF, and now Senator Pat Long and I were talking, and I said, Pat, if I jump over this desk and I come over there and I punch you in the face, somebody calls the police, they come in, they question everybody in the room. They haul me off in handcuffs. I have to post bond or bail. Then I have to go to court and pay the consequences. But if you're my 5-year-old son, DCYF comes out and somehow it gets kicked under the carpet. Kids deserve the same rights we have as far as being protected by law.
Can you explain to us what the bill would do?
The bill would. It would, anytime there's a call coming into DCYF about, a physical abuse or sexual abuse, DCYF, the next move is to call law enforcement. They do not go investigate it themselves. Let's have some professional investigators do the job of investigation. And somehow along the line, that isn't always happening here in New Hampshire, and kids are dying.
Thank you. Questions for the sponsor? Representative Scher.
Do you have any evidence of DCYF not calling police when they become aware of a crime being committed?
With Harmony Montgomery, it's been well published that the investigator emailed Manchester Police after he had been out there to investigate, and said there's no broken bones, there's no cuts and bruises on the kids. I think we're okay. Okay, that's not okay to me. When you've had 17 complaints of brutal violence against somebody, with their kids, if a police officer, somebody with investigative training, had investigated this, we might have had a whole different outcome.
Do you know if a worker from DCYF interacts with a family like that, they come back more often? They're their worker, right? Is that correct?
Yes, I did not imagine so. Yeah.
Would it make sense that they would have a relationship with that family, that they were maybe you said intimidated, maybe didn't want to sour, so they might not necessarily call the police right away?
And that, from what I understand, is what happened with Harmony Montgomery. the investigator knew Adam Montgomery from the YDC Center, and he had been in there when he was a 15-year-old, and he didn't want to rattle him.
So if they were mandated reporters, that would kind of take the pressure off the DCYF worker. He'd say, hey, I had to.
Exactly.
Thank you. Further questions? Yes, Representative Murray.
Thank you, Mr. Chair, and thank you for taking my question. I was just kind of confused with your response to Representative Shear, because did you say that they did report to law enforcement, but then what they reported was that there was no issue? So if I heard that correctly, then how does that bill change what happened?
It's my understanding, thanks for the question, by the way. It's my understanding that it was the 17th complaint. Okay, and after 17 complaints, you have his buddy come out and say, no, there's no problem there. Boy, did the state of New Hampshire drop the ball.
No, but clarify, please. They reported via email and
Via email, yep.
So that was their
and
only report?
this bill would make them report immediately. You get the call, you make another call.
Okay. Does that answer your question? They were. Do you know how long after they reported? Was the email immediate, or do you know?
I don't know, but it was 17. It was on the 17th
Okay.
complaint.
Follow up.
Thank you. Just to clarify, so I guess what I'm saying is if they reported that there was no problem, and now we're saying that they need to report, immediately and then written, then if they're saying there's no problem, even if they had called immediately or sent an email or sent a written report later, would they still have not said that there was no problem in the report? So I guess by changing the timing of the report, how does that affect what's in the report? Do you know what I mean?
Not exactly.
Okay. Do you know what I mean?
I'll translate that one. He reported in the email, there's no problem here. How does your bill make it so that he'd report anything different, even though he's got to call faster?
When the DCYF call line got the call, and these children are being punched.
I see.
That's where DCYF leaves the story, and the Manchester police take over.
So as soon as they become aware of a
Yes.
potential crime, they call. They don't go out there first and investigate, then call.
Exactly.
Got it? Thank you. Representative Muse.
I just have a hope you can help me with a clarifying question. So I'm looking at the current statute, and the current statute says the department shall immediately by telephone or in person refer all cases which there is reason to believe any person under the age of 18 has been sexually molested, sexually exploited, intentionally physically injured so as to cause bodily injury, physically injured by other than accidental means so as to cause serious bodily injury, or victim of a crime, to the local law enforcement agency in the community in which the acts of abuse have believed to have occurred. To me, it looks like our current statute requires DCYF to immediately report these cases to law enforcement anyway. So I'm not quite sure what your bill is trying to achieve that's any different than what's currently in statute.
What OLS said to me is, and a lot of what you read is new language. On line 2, where it starts at immediately, refer is crossed out. Okay, verbally report is the new standard. Okay, to any duty officer, local law enforcement agency in the community. Okay, which the acts of abuse are believed to have occurred. That, according to the bill, is all new language.
I'm just trying to figure out if there's anything different. I mean, what would a police officer do differently with the bill than without the bill?
No, but I'm trying to determine, are you saying that when you had the bill drafted, that was not the state of the law, what he just read to you?
That's what OLS told me.
Okay. So you checked with
I
OLS?
show you here.
Yeah, no, you checked with OLS. What's the
Yes.
state of the
Mhm.
law? They
Yeah.
said, you said then write this bill,
Mhm.
and now we're saying that's
Yeah, and
actually-
they've got all the part of what you said is in changes here.
Yeah, this, I'm just looking at what's posted on our online in our current statutes.
Mm-hmm.
Okay, well, maybe your law passed and we didn't even have to have a hearing. Go ahead.
My question would be, it seems to me that what the report would have been had they immediately reported verbally to the duty officer that there was nothing wrong there. And I don't know if all of the things that you changed down here would have changed the report.
Representative
they
Newman, we
would have
just asked
driven
that
down.
question
It-
and was answered.
Huh?
We just asked that. Representative Murray and I just went through that whole soliloquy.
And di-
And the answer was, at the phone call, the initial report was she was punched. That's when they would have called the police and said she was punched, not after they went out
punished?
there. Punched.
She was, oh, so punched, well, is that in here?
Yeah. So that's what would be different, but we're still doesn't get rid of what
So which one
Representative
of
Hughes said.
these now includes punched as a?
Oh, my God. Did you see anything? No, okay. All right, thank you, Representative Law. We're going to look into that and see what the current statute. If the current statute is correct, what Representative Muse just wrote, it would seem that your condition or your issue's been resolved.
Mm-hmm.
So we'll
Okay.
check into that. Thank you. Who else? Oh, they probably help us out. The chair calls Susan Larrabee and Maria Noonan, hopefully with answers to those questions. Representative Scher.
That's what Representative Muse read is the current statute.
Good afternoon, Mr. Chairman.
Good afternoon.
My name is Susan Larrabee, and I am General Counsel and Legislative Liaison for DCYF.
Good afternoon. My name is Marie Noonan. I'm the DCYF Director.
Thank you.
We did submit written testimony through the portal.
Yep.
However, I do have some copies if you find that would be helpful.
If you want to hand them out, sure. Be helpful if you could tell us what the law says.
Sure. And maybe just to kind of begin as to why we did do written testimony. Because when you look at the reporting statutes, and there's multiple statutes, especially in regards to the response to child abuse and neglect, there are state statutes, as well as the statute here that is presented as a bill today for an amendment, for amending that current bill, that current statute, sorry, as well as federal law and state policies, procedures, and protocols in regards to the multidisciplinary approach to the investigation, the assessment, and the response to alleged child abuse and neglect. So I think we need to look at it as a whole in order to answer your questions and provide information for you all. As you all know, throughout the last couple of decades, we've really honed in on the most important thing in our country, in our state, in our lives, right? The safety of children from abuse and neglect and from crimes against them. It started with the mandatory reporting statute, in which all adults in our state are mandatory reporters when they have a suspicion of abuse and neglect. And that mandatory reporting statute is outlined in 169C29. For again, all adults in New Hampshire are mandatory reporters. And then in return, in 169C38, we, DCYF, the Department of Health and Human Services, we are mandatory reporters to law enforcement when there is a suspicion that a child has been a victim of abuse and a victim of any crime whatsoever. So you are right, that is not being changed with this bill. What is confusing about this bill is when it is to be referred. So what also has enhanced our response to childhood abuse and neglect is other statutes. For instance, 169C34 outlines our duties and responsibilities and our timeframes around the commencement of investigations of abuse and neglect. And that is what's called the duties of the Department of Health and Human Services. And as you see, it outlines the most important part of this statute, in my opinion, is that if it appears that the immediate safety or well-being of a child is endangered, the family may flee, or the child disappear, or the facts otherwise so warrant, the department shall commence an investigation immediately. And that's our duty, to begin that investigation immediately. And also, under the reporting statute, it's our responsibility to notify law enforcement when there is a belief that a child has been a victim of a crime. That happens at the district level of the jurisdiction of the district office. They refer to law enforcement, the local law enforcement, with a phone call, and they follow that up with what's called a law enforcement notification letter, laying out what is alleged to have occurred and beginning that joint investigation process. Because what we have learned over decades is that that is the best for all of these cases, to be treated as a multidisciplinary team approach to the response to child abuse and neglect. And stakeholders, which include law enforcement, DCYF, the child advocacy centers, prosecutors, therapists, came before the legislature in 169C34A to bring forward that legislation years ago, when we were finally coming up to par with other states and putting child advocacy centers in every single county in our state to work together collaboratively to investigate these cases. And what's also mandated in that statute is that we put together these protocols, the protocols for the best practices for following the law, both state and federal, and for working together as a joint partnership to investigate these cases. And that is the protocols. And I provide a link for you all, because it's out of the Department of Justice, the Attorney General's office. It's made up of a task force as required by the statute that says there is to be a multidisciplinary task force to study and advance these protocols. And these protocols are to be given to the legislature. These protocols are to be on the public-facing website for each discipline to then be trained in these protocols for, again, the best practices of investigating and responding to abuse and neglect. And I don't have enough for everybody because it's quite, I don't want to kill too many trees, but I do have enough that we could pass them around. And you will see the chapters are laid out in the table of contents when it talks to all the disciplines involved in the response to child abuse and neglect. And I will specifically point to the appendix, which is the last few pages, and this is Appendix D, when it comes to the joint guidelines for DCYF and law enforcement on mandatory notification, record sharing, and investigations. Specifically, Roman numeral 1, that talks about the flow between the mandatory reporting to DCYF to law enforcement with that phone call, and then with that law enforcement notification letter. And if you want to, I can stop talking for a few minutes if that would help, but I think that would lay out and answer many of the questions about the reporting that happens in a very formal way.
If I could just quickly, what section does the bill purport to change?
Sure.
Is it 169C29? 38.1?
Yes, correct.
Department shall immediately, okay, that's right. So how is the current language in the statute different from what he's asking for in the bill?
So we're assuming that when it struck the word refer, that it says the department shall immediately by telephone, and then there's some additional language of how that telephone call is to occur, that is to occur to an actual law enforcement officer, and then it says that if no law enforcement officer is available, to then call state police, which again, I'm not law enforcement and I'm no longer a prosecutor. I'm a DCY general counsel, so I can't answer that question. But typically we would, as you see in the flow chart, we are calling the local law enforcement because they have jurisdiction over the case, and state police would not have jurisdiction. So it would change that, and then it would assume that if they're talking about striking the word referral, that's what happens when it gets sent to the local DO, as we call it, the local district office, that has jurisdiction over that family, over that kiddo, may know that family, may know the law enforcement. So that's when the joint investigation begins. The way we're reading it is that it would be required that it's actually the central intake worker who would be making that phone call to state police.
How long does it take before it gets sorted through to your district office and the decision is made to call law enforcement?
Typically, it's a matter of hours before a screening decision is made, but certainly our central intake or our hotline staff are trained, and any immediate danger would be immediately notified.
So if a call came in that said, across the street, I just saw the man punching his daughter in the face, someone needs to look into this. Does your intake officer call the police right then, or do they refer it to the district?
Yes, and they would also probably advise the caller to call 911
And
if they
do
saw
you
a
have
crime in
that somewhere
process.
in your policy or procedure? That the intake is supposed to call right away if they see or hear a more urgent nature to the call?
So I'm not sure if that's in policy. Our general counsel will look.
Okay.
But our central intake or our hotline staff are equipped to make decisions around timeliness of response to a particular report based on the information that they receive. So there are screening decisions, and we have reports called level 1, 2, and 3.
Yeah.
So in our level 1 reports, those are our most serious reports. A child is in danger now. So again, 911 may need to be called,
Yeah.
but also a screening decision would be made immediately as soon as we have enough information to make that decision. The local office would be notified by phone. This happens very quickly. And then the local supervisor would be connecting with the local police department to make that immediate notification.
Okay. Is there anything further you wanted to present, Counsel?
And just to clarify, again, we're not opposed to this bill, we're not in support of this bill, we're here to offer information, but we're also here to offer information and make sure that there's not unintended results happening here. Because as Director Noonan stated, when there are those, what we call level 1s, those immediate concerns for the immediate danger, based on the other statute that says that federally and statewide, we have to abide by that. We want to, of course, reach out to law enforcement immediately. That's the best practices. But there are multiple levels of what we call level 1s, which are those, let's go. Everyone needs to be ready to dispatch. And we always have an on-call supervisor for that. And last year, in the state fiscal year of 2024, there were 1,173 what we call level 1s that resulted in a notification to law enforcement. A level 1 that rise to, it may be a crime against a child. However, there were also over 2,173 level 2s, and I did provide policy and procedure that discusses what each one means and how they're defined in our work, as well as a level 3, 2,254. So of the 5,700 reports to law enforcement, the way we read the bill, that would be immediate dispatch to police. And if there's no local police available, that we would be calling state police. That would be over 5,700 calls that would immediately flood state police. And we're concerned that that would have unintended results.
I think
That-
state police is if you were to call the local police, and some towns don't have police, or some towns only have police between certain hours of day or night. So in other words, if you can't reach them, you call the state police. So I don't think that means flood the state police.
Correct.
So you're saying that under the way the bill is written, all of your calls would go right to the police. Is that what you were just saying? You said 5,000?
That's the way we've interpreted it, and we made that assumption when we were doing the fiscal note worksheet, and that's why it's quite a high fiscal note impact, because that would require, especially during after hours, during after hours and on the weekends, which is defined as now being included as that written report, whether it be a level 2 and a level 3. 'Cause level 1, that would immediately go out anyways. But the level 2 or level 3 would now have to go out and be dispatched to our local DCYF as well. And our on-call provider is a contract called, with,
The Home for Little Wanderers.
So, the levels, I think I'm looking at the right thing. Report to law enforcement, is that the page I should be looking at? It's 1172.2. Second to last page in the handout you just gave us.
there's actually a chart. Let me find the chart. 1150.1.
Well, since I have it open, can you refer to 1172.2, report to law enforcement? I'm kind of curious what this is. It's got levels too.
Yes.
It's the second to last page. Yeah. What?
Yes, that's currently in
Missing
policy and
pages?
procedure, what's in the law, that we are to verbally report to law enforcement.
Okay, so that's what this is?
Yes.
So let's look at that for a second. So it says level 1, the death or presumed pending death of a child is a critical incident, must be reported in accordance with 1099 critical incident reporting case specific. I assume that means call right away. Is that what that? But now we go down to level 2 and we have sexual abused, exploited, physically abused, neglected, victim or exposed to human trafficking. This one also says will verbally notify law enforcement immediately by phone or in person when a report is received or a new allegation is identified in the course of the assessment. So that's also a right away. Verbal notifications made to law enforcement where the crime is believed to have occurred. That's you're saying the local law enforcement.
Right, but
Yeah,
I think there might be misunderstanding. The Roman numeral 1, 2, and 3
yeah,
aren't the levels.
okay.
The levels are described in 1150.1, report types, screening decisions,
Yep.
and response priority levels. And there is a chart.
I think we're missing a page.
I apologize. There is a chart that includes level 1,
Uh-huh.
the factors of level 1, the factors of level 2, and then the factors of level 3. And those coincide with not just state law, but federal law called CAPTA, the Child Abuse Prevention and Treatment Act.
Okay. Is that chart available on your website or? How-
Yes, and in the letter of my written testimony, I identified each
Okay.
with a hyperlink to the actual DCYF policy manual and identified the policy and SOPs relating to each of the levels and each
Thank
of the
you.
response times.
Thank you. Okay, was there anything else you wanted to present?
If I could provide a little bit of explanation as well in regard to the prior testimony heard, and certainly I can't speak about case-specific examples or actual cases. So when a report is screened in and it's sent to the local office as attorney represented and the office communicates with the local police department, it is the supervisor. So our joint protocols through the Attorney General's office speak to that the supervisor at the local office is responsible to ensure the law enforcement notification both verbally and in writing takes place. So that is the procedure. The assigned CPSW to a particular investigation is not the first outreach to the police. So I want to make that clarification to our practice and policy.
So that supervisor doesn't wait until the caseworker goes out and comes back with a report though, right?
No,
Okay.
it makes that immediate notification upon
Okay.
receipt of the information.
Okay, great. Further questions? Representative Muse.
So, so it sounds like in some areas, the bill that's in front of us is duplicative of existing statute and in other ways it it tries to make some helpful additional corrections that may not be as helpful as intended. But given the scope of the problem and given given the fact that incidents like the Harmony Montgomery incident have happened, what can we be doing in statute that we're not doing now that would help?
So one thing that's new in the bill, however, I do want to point out that it is in our joint protocols, but in line 24, law enforcement shall not rely on the department to gather information for its investigation. So that section is new and is not in the statute. So that is a piece that I'll draw your attention to. However, the joint protocols do outline what each member of the disciplinary team should be doing. So that law enforcement would be conducting their investigation, DCYF would be conducting its investigation, a CAC would happen to interview the child to minimize duplicative interviews, and then the parties all work together. But if I were seeing something new, this is the piece that would be new in statute today.
You just said avoiding duplicative interviews. The police department conduct their own interviews and investigation in all these cases, correct? They don't rely on your investigation.
The way that when children are potentially victims of crimes, we have child advocacy centers set up in each county where trained forensic interviewers.
Like a sane interview type of situation. Yeah, I get that.
Yes.
Okay.
So the law enforcement would be a member of that multidisciplinary team at the interview so that everyone's witnessing that.
That's for they're talking about, that's related just to the victim. But what about the investigation of the home and the parents and witnesses? The police are still doing that themselves. They're not just taking the DCYF caseworkers report, correct?
That's what the protocols would direct,
That they would do it themselves. Yeah.
that they would have their own investigation.
Okay, thank you.
And we would collaborate.
Okay. Yeah, they do. I can't imagine a prosecutor would rely on that. Wait a minute, Representative Bogart, you had a question?
Yes, thank you for allowing me to ask a question, and thank you for taking my question. If I understood correctly, within your protocol, it is set up to call the local law enforcement agency and then the state police. Why would we not call the sheriff's department as the intermediate for that county in there instead of the state police?
Actually, our protocols say law enforcement agency. It does not say state police. The bill says state police. And that's what we are addressing in terms of there may be some jurisdictional prohibitions against state police taking ownership of a case that they have no jurisdiction over.
Just to be
And
clear, the state police have jurisdiction statewide.
I'm sorry?
Just to be clear, the state police have jurisdiction statewide if they choose to exert it. But I understand what you mean about wanting to keep it within the local jurisdiction. Representative Newell.
Thank you, Mr. Chair, and thank you for taking my question. I just am curious about on lines 24 through 26. Law enforcement shall not, you were just talking about this as well, shall not rely on the department to gather information. I work at a homeless shelter, so I am a mandated reporter in that way, and kind of have been through this myself. But the process involves, the investigation involves a lot of information that I think is gathered by mandated reporters along the way, in history of different offenses and or different reports and kind of to form a pattern. And I'm just wondering if something like stated the way that it is, if that would interfere with that being a part of the investigation.
If I understand the question, are you saying that this may be too prescriptive in terms of not allowing law enforcement to use a piece of, I would use the phrase, I guess, evidence that we collected during our civil investigation into abuse and neglect in their criminal case?
Right.
And I think that allows for, unless such reliance is required or necessitated by the standardized protocols.
Okay.
Because of course, if for instance, hypothetically, if a law enforcement agency is unavailable to attend the CAC, they're of course going to be made aware of the CAC and given a copy of that recorded interview. They're not going to be expected or advised to do a re-interview of a child merely because they weren't present for that interview. If that answers your question.
Yeah, it does. Thank you.
But to follow on that, law enforcement wouldn't, for example, rely on a report you wrote. If they were going to charge somebody with a crime, they would have to do their own investigation, because then you become a fact witness to testify in court when, well, you maybe do, but you're not, you can't bring a charge. So they would use your report, but it would be
Right.
to build their own.
Yep. Thank you.
No further questions. Thank you.
Thank you all for your time.
Thank you for your helping us in this voluminous stuff, and I'm going to look up that website. Chair calls the Honorable Erica Leon.
Thank you, Mr. Chairman and members of the committee. And I appreciate you taking the time to look into this thoroughly. As I expect that you are likely aware, especially given that the Vice Chairman of Child and Family is sitting here today as well, there are a number of bills trying to deal with the fact that right now it is overly difficult to get a conviction of a parent who has caused physical injury of their child. I'm thankful that the Criminal Justice Committee is also looking into this, because the evidentiary standards, the due process, the ability to have appropriate counsel in interviews is different in the criminal system than it is in the civil system. And I want to ensure that there's all the protections needed to be able to secure a conviction of somebody who is striking their child or is sexually assaulting their child, so that we can make sure that the criminal system also steps in when a crime happens against a child. So I thank you for looking into this.
Thank you. Anybody else? Anyone else wishing to testify in this bill who hasn't done so? Seeing none, I hereby close the public hearing. And what's our next one? What is it? I hereby open a public hearing on House Bill 445. Which one is it?
Which is you.
Yeah, I know.
Representative Roy, if you could hold on one second. Okay.
Thank you, Representative Terry Roy, Rockingham 32. I'm here introducing my bill 445, establishing a study commission to examine the causes and ways to alleviate the shortage of law enforcement officers in New Hampshire. I think the members of this committee, more than anyone else probably, understand how short we are with law enforcement in this state, how difficult it is for them to be able to attract and keep talent. And I think that based on my years of experience in here, we need to focus on this as a legislature and see, are we doing everything we can to enable our municipalities and our agencies to hire the best talent that's out there? We're holding our law enforcement officers to a higher standard than we ever have before, which is a great thing. We want to make sure that they have the ability to get the talent we're demanding they have. So I've put this bill together to get this commission. A committee is too short to even begin to work on something like this. I have had some requests to add a few people to this, and I'm going to do that before we would exec it. I'm going to add the state prison commissioner, and I'm going to add sheriffs because I seem to have neglected them in here. And I'm open to any other suggestions with regard to this. I just think it's a very important thing to look at. I know money is tight, so we might not be able to throw money at it, but I've had some other ideas. For example, we own a state college. What good is owning a college if you don't use it? we could set up a system with UNH where new officers who sign a contract to work at a department for some certain number of years could have their tuition waived for their criminal justice degree. That's just one idea. There's a lot of different ideas that can be, but I think we need to examine them. So that's why I brought this bill. I'd be happy to take any questions.
Representative Muse?
I do have a question and a small amount of expertise in recruiting and things of that nature. One of the things that strikes me about the list is the potential is there because all of the folks are related to law enforcement for you guys to have a lot of great conversations about how bad the problem is. And maybe fewer conversations around things to resolve the problem. I'm wondering if it would help to have somebody on the commission who is outside of law enforcement, but who is an expert in things like recruiting, retention, and strategies that can be employed. I know that there's a lot of interesting work that's taken place in the last few years outside of state government when it comes to this, and maybe some of that expertise could be put to use.
That's a good idea. It sounds expensive, but it's a good idea. Maybe we can start with state human resources and recruiting, but you're correct. Maybe checking with SHRM or something like that. We might be able to get a,
Yes.
yeah.
Representative Matson? You didn't have a question? Oh, I'm sorry. I thought that was the thing. I'm sorry. Representative Shear?
I think as Chairman Roy knows, Manchester is down 24 officers, state police are down 65 officers. We in Portsmouth are down 7 officers, and we have a very aggressive recruiting plan. I think you can find either at UNH or maybe you may want to include Southern New Hampshire in this, individuals who have expertise in really what we're talking about is marketing. And I would suggest something along those lines. I can talk to you about how to word it.
You mean within the college system?
Within the UNH, the system, or Southern New Hampshire also. I know from my work as a commissioner that we see graduates of Southern New Hampshire also. What we're talking about is criminal justice programs, and they have a criminal justice program.
Thank you.
So would you believe that would be a good idea?
Would you
Chairman Roy?
believe that would be a good idea?
I believe that would be an excellent idea. So far from what I've got from the committee is some marketing and some human resources suggestions. I like those. Any other questions or suggestions? Because the next time you see me on this, it will be with an amendment and an executive session.
I don't see any.
If you have any between now
Representative
and then,
Miller, did
you
you have
know
a
how to
question?
reach me. And I'd be happy to work with anyone on the committee interested in this topic.
Looks like you're off the hook. Run. Commissioner Hanks?
Red is on. Good afternoon. For the record, Helen Hanks, Commissioner of the Department of Corrections, and to my right is Captain Pete Ash, a member of our law enforcement officer rank and file, who's in his 25th year with the department. I want to thank Chairman Roy and the others who authored this bill and for his offering to amend it to include the law enforcement staff at the Department of Corrections. We are here in full support of this bill and the idea that the legislature could convene the right partners together to talk about recruitment and retention. And I just want to lean in a little bit too and remember that at the high school level, there's a opportunity there as well. And we teach an extra credit course in corrections, both at Berlin and Groveton schools. And I think that there's another space for that in this type of commission. Captain Ash has been with our department long enough to see what happened before I took the helm, and I just want to give him an opportunity to talk about his prior experience and the things that we've done.
Good afternoon. I started in 1999. I was a 20-year-old kid. I had a grandfather that worked in corrections, so I knew a little bit about it, but didn't know what I was getting myself into. For years, we had one security officer that was in charge of recruiting, and not much help to get people in the door. So a lot of people would be in the waiting process and find another job. Since Commissioner Hanks has been on, she's developed stats to find out where we're failing. Over the past several years, she's been able to do a lot of things as far as getting raises for our staff, which we're trying to bring more people in. We started a recruitment retention committee. We've expanded that and put a lot of our officers, including myself, on to find out what it is that we can get people to attract. Corrections is not a very attractive job. A lot of people don't understand the sacrifice that people make inside those walls. It's not something that's advertised, so it's a very difficult job to recruit for. But since commissioners put in a lot, we have 2 sergeants right now that are part of recruiting. They go out to the schools, they go out to job fairs, they go out to events. We're trying to get ourselves out there. So
So certainly if there are any other questions, but we're really mainly here in support of amending the bill to include us and thanking those that brought it forward, and I just want to be part of the solution.
Captain, did you say the jobs are not advertised if there's an opening at the facility?
no, they are advertised
Oh.
now. Years ago, it was just a newspaper article, but since then we've had commercials and a lot of advertisements,
Oh, okay.
billboards. So
You said they are advertised.
Are, I'm sorry. Yeah.
My bad. Okay. Representative Knoll?
Thank you, Madam Chair, and thanks for taking my question. I happen to know one up-and-coming officer-to-be. He's my oldest. And he has for 2 years been trying to get into a criminal justice course in his high school, and they can't find a teacher to do it. So the recruitment in a variety of ways. Do you think that being able to offer that and also focusing on having criminal justice teachers in the schools would be helpful?
Representative Newell, I think that's a great idea. Again, to Captain Ash's point, a lot of people don't know what we do in corrections as a form of law enforcement in New Hampshire. And as one component of the justice system, we're missing an opportunity to teach our young people what those are and how to pave a path post high school. And some of those opportunities can happen right after high school, and some could happen in collaboration with our university and college systems.
Thank you.
Thank you.
I don't need specific numbers, but I'm curious to what degree you're able to hire people from out of state, or is the hiring mostly of in-state people?
Representative Sher, that's a great question. We have some individuals that are coming from out of state. We did a pretty assertive marketing campaign, understanding our, I'll call it our digital audience. So whether it was Facebook or Instagram, who's looking at our page, and we had a contracted marketing partner for a short period of time. So we did draw some people from New York. We drew some people from Vermont and Maine. We are actually, interestingly enough, drawing some people out of Massachusetts. The furthest away we drew someone to move to New Hampshire was Montana.
Follow up? Have you had any success with lateral hires outside from outside the state?
I want to make sure I understand your question. When you say the term lateral hire,
People who are already corrections officers in other states.
we have had some success there. I want to just say not every state has their corrections officers as certified law enforcement. So we've drawn the individual from Montana, worked in the Montana Department of Corrections. We still put them through our corrections academy. We've hired an individual from Vermont Department of Corrections. So we get some spots of those that relocate to New Hampshire.
One last follow-up. To what extent do you hire people who are leaving a police department?
That is a more rare occurrence. We do on occasion, we have a full-time person who retired from a local municipality up north who then now works at our corrections department full-time. Thank you for those questions.
Representative Murphy?
Thank you, Madam Chair. And thank you, Commissioner. I represent the town of Merrimack, and in Merrimack we have our police department has created an ELO, extended learning opportunity for students interested in criminal justice. I wonder, I mean, I know it's early, it's not quite like an NHTI program that would maybe lead to something else, but would there be any value in working, looking to see where you guys can establish a relationship with those high schools throughout the state that have those kind of extended learning opportunities? And if not, encouraging them as to how that might be the routine, you know, the gateway to the other our state programs for education in that program.
You know, Representative Murphy, that's exactly what we're doing up in the north region, and we would love those to expand themselves. I think for us as a department, we're not the experts in how to navigate that relationship. I think this commission could help us understand how to do that better and consistently across those high school programs and other programs that want to offer it. Thank you.
I don't see any more questions, but I do have a question myself. My clerk has informed me that she thinks that this is Ms. Graham's handwriting. Was this you, Commissioner, or is this the neatest handwriting I've ever seen in my entire life? Like, she didn't even use the lines, y'all, and she is exactly like straight across. I need to go to, wow.
She may be one of the best people I know, and her handwriting being the best does not surprise me, ma'am.
Holy, wow. Go you, Ms. Graham. Okay.
Thank you, everyone.
Thank you for coming today.
Appreciate it.
Is there any is there anybody else here wishing to testify on House Bill 445 that is not turned into pink card? Seeing none, I will close the public hearing. And our next hearing is at 3:15. Buckle up, it'll be a long one.
Buckle up, buddy.
Good afternoon, everybody. If you could please take your seats, get yourself situated. We are going to open the public hearing for House Bill 159. After the sponsor introduces the bill, we do have not a ton of cards, but a decent amount. We are going to limit testimony to 3 minutes. We would ask that if the person before you or at any time before you says what you are going to say, if you could just yield. If they do say the same thing, it means that they did a really good job. So just give them a high five and say thank you. At this time, I am opening the public hearing for House Bill 159 and invite the prime sponsor to introduce his legislation.
Thank you, Madam Chairman and members of the committee. Representative Roy Rockingham, 32. I am here introducing House Bill 159. House Bill 159 is related to House Bill 1711 from last year that I brought that cleared the House and it died in the Senate. Over the summer, I was contacted by the nephew of Chief Haas, the security officer who was murdered at the New Hampshire hospital last year, and he asked me to refile the legislation. I've been working with the National Rifle Association to make some changes to the bill, and I've heard from various members of the House, and I've made some changes based on that. So I have passed out an amendment. What I've taken out of the bill was the confiscation piece. So what it said before was once you were notified by the court that you had been committed for being dangerously mentally ill to yourself or others, the court would notify you that you were now a prohibited person per federal law and state law, and you had to turn over your weapons. And that was causing a lot of consternation among the public and other members because, frankly, weapons are very expensive, and we just don't really feel comfortable with them going into what would appear to be a black hole, and no one knows where they were going to go. So we took that piece out to get that complication out. What it now reads is the court will warn the person you are not supposed to have firearms, and you may transfer those firearms to someone else or to a licensed dealer, or if you have no one else, you can give them to the police, but it's not mandatory. So I took that out. So just to start with, the bill, what the bill does is currently there's 48 states in the country, 48 states and the District of Columbia and Puerto Rico, whereby they follow the federal law where that says that if you become a prohibited person from owning a firearm, if you are found by a court of competent jurisdiction to be a danger to yourselves or others, and you are committed to involuntarily to a mental institution, those states and territories other than us notify NICS when that happens. So what NICS is the National Instant Criminal Background Check System that was actually instituted many, many years ago at the request of the NRA, because it used to take sometimes weeks and months to be able to buy a firearm. So they came up with the idea of NICS instantly so that people could instantly get their firearms. So it was a cooperation between all of the states, because it doesn't work if the states don't work with it. All the information in NICS doesn't come from the federal government, it comes from the states. So when you are convicted of a felony, that's submitted to NICS, no matter what state you're in. If there's a restraining order or protective order against you, that's put into NICS. That's part of that agreement. And you are blocked from buying a firearm. So in 48 other states, they report when someone has been found a danger to themselves or others and committed. In New Hampshire, we don't do that. And because of that, and I can say this clearly now because it's been proven, Chief Haas is dead. The person that shot him had been committed twice. He should have been reported. And after he was committed, he went to a store in New Hampshire, he purchased firearms, and he went and murdered Chief Haas. Now, can I say that it wouldn't have happened otherwise, that he might have got them some other way? Possibly, but that's not what happened. What happened was is he went to a store and bought them, and he was able to do so because we did not report him. Another thing that's very concerning is we could be the problem for someone else. New Hampshire doesn't have a wall around it. People can leave. So when you're committed, and you're mentally ill and you're prohibited, you might decide, I'm just going to pack up and move to Texas. And you get to Texas and you go buy a firearm, and then you stop taking your medication and things aren't going so well for you anymore. And you start hearing voices again because you may have schizophrenia or some other illness. And you shoot someone down there. Well, it's going to come out, that person came from New Hampshire where we don't report. So that's problematic because the rest of the states are playing by the rules that we all agreed to, and we're deciding, no, we're not going to. So that's troubling for many reasons. So a lot of people, I've been getting hundreds of emails, maybe you have too, that keep saying, don't do this. There's no due process. This law is literally replete with due process. In order to be found dangerous to yourselves or others and committed, you have to go through a hearing. And it's in the statute, it's so clear. You have to go before a judge. You are assigned an attorney if you can't afford one. You are allowed to cross-examine witnesses. You are allowed to put on witnesses your own defense. You are allowed to appeal his ruling. It is the very definition of due process. So no one's rights are being taken without due process. And frankly, we're not taking anyone's rights anyway. It's the very instant that judge says you are committed, by federal law, your rights are suspended. Now, another important piece that the emails don't seem to mention is that I've put for the first time in our New Hampshire statutes a way to restore your rights. Currently, there are people in New Hampshire, hundreds of them, who cannot buy a firearm because they were found dangerous by their doctor. You can be put on this list, and people don't often realize this. This isn't the only way to get on that list, is the commitment part. Another part is doctors are mandated reporters. And if you go to your doctor and you're talking to them and you tell them that you've been thinking about hurting someone or yourself and they think it's credible, they're mandated to report that to the Department of Safety. And they do. And you go on the list because that's not protected. What is protected in our statute is these hearings for commitment. That's the reason that we need this law, because the Supreme Court said that the commitment hearings had such privacy built into them that we couldn't report it without the statute. So there's people in New Hampshire right now who cannot buy firearms because their doctor said at one point in their life they were dangerous to themselves or others, and it was reported. Now, maybe they had a bad time, bad weekend, bad year, and they're better now. Well, that's too bad. They can't get it back. The federal law will not allow a person's name to come off that list unless the state has in statute what's called a restoration of rights process. And in that, you have to go before a judge and you have to have a doctor say that you are no longer a danger. And once you do that, you can get your rights back. But currently in New Hampshire, it's a life sentence. You are never going to own a gun again legally. So just to sum it up, this law, if it passes, would affect such a minuscule population. It's people who have been committed to a mental institution involuntarily. And so that means not folks who went to the doctor and said, I need help, or checked in themselves to get help. Involuntarily committed after having a due process hearing where they had an attorney, their name will be reported to NICS. And they cannot buy a firearm or possess a firearm. This law also gives them hope, where they have none now, where they could get their rights back. When they're better, have their doctor say, this person is no longer a danger. And then they can go back to court with that letter and say, Your Honor, I'm better. And they can get their rights back. So it does two things. And with that, I'd be happy to take any questions.
Representative Muse?
I do have a quick question about your amendment. As I understand your amendment, it would allow somebody in this situation to voluntarily relinquish their firearms, but what it would do is it would remove the clause in the prior bill that allowed law enforcement officers to confiscate those weapons after 48 hours. Is that correct?
That's correct. It removes the confiscation, the forceful taking of the weapons by law enforcement is totally gone out of it now. Now it's left to the judge to work out with the person or their family, however they can work it out, whether the person has firearms and they get those firearms safely taken somewhere else. The police are taken out of that.
Follow up? What if the person just simply decides that they are not going to agree to relinquish their firearms?
That is then, well, that depends. It's not, the statute doesn't contemplate that. So, I mean, if the person says, I have firearms and I'm not giving them to you, that would be between them and the law enforcement, who they say that in front of, I guess, that they've admitted they're a prohibited person with firearms. What this does is it prohibits the police from going to people's house and starting looking around for their firearms. Or if someone says, I think he's got guns, and the police being able to go look for him. So it's going to a place where the people hopefully are going to be honest with the court, or hopefully their family members will help them and get those firearms out of the house if they have some. I think we're looking at this point more proactively. Let's see if we can, before these folks actually purchase firearms, which is the really crux of this bill, is to keep people from going out after this happens and be able to purchase firearms.
Thank you.
Everybody good? Seeing no further questions, thank you very much. Dr. Strang? Pardon me, if you could just hit the button so that the red
Got
light,
it.
it's actually opposite. Red means go here.
I'm an emergency physician with 35 years of practice experience in the field, and I'm here to testify against this poorly worded and dangerous bill. This bill would allow the state of New Hampshire, and then by report, the federal government, to be in possession of confidential, personal mental health data. The authors try to claim that it doesn't, but in fact it does. 3 times before you even get to the text of the bill, it states, quote, an act authorizing the state to report mental health data, end quote, or, quote, this bill authorizes the state to report mental health data, end quote. 3 times it states that just at the very beginning, allowing any government for legal purposes to be in possession of private medical information shielded by the long revered and protected principle of doctor-patient confidentiality should put shivers down your spine. Section 159G:2 lists 3 distinct criteria which would allow the state, using confidential mental health information, to revoke someone's Second Amendment rights. All 3 criteria are most often temporary in nature. For example, an elderly man loses his wife and now suddenly, as a widower, is so consumed by grief that he wants to die and join her in heaven. Family or perhaps a neighbor calls the police, who bring him to the emergency room for evaluation. This is what I see regularly in my work. He is then evaluated by a mental health crisis counselor, whereupon he repeats his desire to die and therefore is committed involuntarily to a mental health facility, and in doing so, his firearms are taken away. He could give them to a family member, but he has no choice in that matter. The state will determine if they are surrendered to a federally licensed firearms dealer, and if they are, he must pay to have them restored, which is a violation of his Fifth Amendment rights against the unjust taking of private property. Returning to my example, in just 2 weeks, counseling and perhaps an antidepressant has helped him to resolve his reactive depression, and that's an actual medical diagnosis and is very easy to understand. And he is cleared for release home. But now he must embark on a fight to restore his right to keep and bear arms as guaranteed under the Second Amendment. This brings us to the chapter 159G6 exclusions section of this bill. Chapter 159G:6, Roman numeral 1 states, quote, neither the court nor the Department of Safety shall transmit information on persons seeking voluntary treatment or on persons involuntarily hospitalized for assessment or evaluation. Now, the authors of this bill may have meant to write voluntarily hospitalized instead of involuntarily, but as written, this language is in direct contradiction to section 159G:2, Roman numeral 3, where it states an involuntary hospitalization will in fact cause someone to lose their Second Amendment rights. It can't be both. Does everyone see that contradictory language, or do you need me to explain that further? In seeking relief, he would now have to petition the court, whereupon an independent psychiatric evaluation would determine if he is allowed to once again exercise his Second Amendment rights. But who determines who this independent psychiatrist is? The bill does not say, but it appears to be the court. Would any of you, if accused of a crime, think it fair if the jury was chosen only by the prosecutor? That your
Doctor-
defense attorney has no say in the matter?
As much as we would love to hear the rest of what you have to say, we do have a 3-minute time limit.
I'm almost done.
Okay, but I already let you go over about 25 seconds.
Okay.
So thank you.
I have written testimony. I'd be happy to provide a copy for all of you.
That would be fantastic. Thank you very much.
Okay, thank you.
Just a friendly reminder, everybody, we do have a 3-minute time limit. I'm doing everything I can to stick to that. Kathleen Slover.
Hello, my name is Kathleen Slover. I'm from Portsmouth, New Hampshire, and I'm representing myself. Even though federal law prohibits people with certain types of mental health adjudications to possess and purchase firearms, the federal law cannot require states to make information identifying these people available. So it's up to the states. And a lot of the states moved the needle in 2007 when a Virginia Tech student shot and killed 32 people and injured 17 others before dying by suicide on the college campus of Blacksburg, Virginia. The gunman was in fact prohibited from purchasing a firearm under federal law because of a history of mental illness, but was able to purchase firearms after 2 background checks. Virginia increased its reporting of mental health records, and it resulted in blocking other gun sales in Virginia for the next few years. From 2007 to 2010, there was a 47% increase. It's up to the states to take the responsibility. It's by federal law, so I hope that you support this bill. Thank you.
Ms. Reynolds.
Hi, Kristen Reynolds from Swansea, New Hampshire. I moved from Portland a few years ago, and I had there some experiences that really changed the way I thought about gun laws. Previously, I would have supported a gun law like this, but then I lived through some things and I wanted to just share them. So, in Portland in 2020, with the lockdowns, we had chaos. And the police were not coming to people's homes to help them. And the gangs were out. And I had gunshots all around my apartment constantly. So I learned when there's chaos, when there's a problem, the police aren't necessarily there to help me. That was one lesson. The second lesson I learned also during that time was it's amazing what can become a mental illness. People who did not decide to take the experimental vaccine were suddenly thought of as mentally ill. So it's very concerning because it can become very political who's mentally ill and who's not mentally ill. So I learned that. Second lesson. Third lesson. My son, when he was 25, living in an apartment in Portland with housemates, had someone just walk into his home, come up the stairs, and go straight towards his female housemate. He ran into his room, got his pistol, pointed it at the guy. Guy left. That was a very powerful lesson. And since that time, I support guns. And when I moved here to New Hampshire and everybody has a gun, surprisingly, I felt the safest I ever felt in my life. So there you have it. I am opposed to this bill.
Thank you very much. Ms. Moran?
Happy Friday. I'm testifying on behalf of the Women's Defense League. This bill is an emotional, knee-jerk reaction to the horrible murder of a former law enforcement officer turned unarmed security guard at the state psychiatric facility. There's nothing in this bill that would have prevented that tragedy. There's nothing in this bill that stops, even with the new amendment, there's nothing in this bill that stops violently mentally ill people from committing criminal acts against their innocent victims. And I haven't had a chance to really review the bill and go through all the words, but even the amendment still intentionally discriminates against gun owners. It's the different language, same outcome. And there are many cases of mass criminal acts committed by the violently mentally ill where firearms are not the object chosen. Why aren't matches, lighters, knives, automobiles, pressure cookers, or other objects being confiscated or turned in as well? Gun control laws such as this one do not stop criminals from either getting firearms illegally or from using other objects to commit violent acts. A U.S. Department of Justice report from 2016 shows that a majority of imprisoned criminals obtain their firearms illegally. This bill does nothing to stop that. Reporting this info does nothing to stop that. This bill does nothing to stop violently mentally ill people from committing any crimes. If someone is violently mentally ill, why are they living in society? Why aren't they in safe facilities where they cannot hurt themselves or others? I'll answer for you. Because psychiatrists lied and told politicians years ago that violently mentally ill people would be just fine in society if they only took drugs that were untested in long-term clinical trials. Politicians believed them and shut down mental health facilities across the country. This project was an abject failure in many ways, but most importantly, violently mentally ill people do not get the help they need and are living in society where they have easy access to act out their violent aggressions against innocent victims. This bill does nothing to resolve that. This bill still points the finger at gun owners. And the reality is the finger should be pointed back at the psychiatrists who pushed for this failure and the New Hampshire legislature for doing nothing to remedy or solve the actual issue in regards to violently mentally ill people. We need to have more mental health facilities open so these people can live out their lives safely and safe from society. And I'll note, on the side, a majority of those with mental illness are more likely to be victims and criminals. This is referring to people who are diagnosed as violently mentally ill. Please vote inexpedient to legislate on this bill. Nothing is being solved with this bill, not even with what I've read from the new amendment. We need legislators with courage to stand up and work on the real problem of violently mentally ill people in our society. Thank you.
Thank you very much. Ms. Thurber?
Hello, my name is Simonida Thurber. I'm from Exeter, New Hampshire. According to the current federal law, people who are involuntarily committed to a psychiatric facility are already prohibited from possessing or purchasing a firearm. However, New Hampshire currently does not report those cases to NICS, or the National Instant Criminal Background Check System, thus making national firearm background checks inaccurate, incomplete, and ineffective. House Bill 159 would close this glaring and dangerous loophole. When last year's version of this bill was being considered in 2024, Governor Sununu, who, as you know, is a big supporter of gun rights, he supported the passage of the bill. And according to the NHP article from May 17th, 2024, Sununu said, "This is clearly a loophole that has to be closed, and I'm supportive of the bill." Please vote in support of House Bill 159. Thank you.
Thank you very much. Dr. Hink?
Good afternoon. My name is Dr. John Hank. I'm representing the New Hampshire Psychiatric Society and the New Hampshire Medical Society, and both societies strongly support House Bill 159 as important legislation to reduce the public health crisis of gun violence in our society. I've worked as a psychiatrist at New Hampshire Hospital for many years, and I was working at New Hampshire Hospital on November 17th when gunshots were heard in our lobby. All the patients and staff at New Hampshire Hospital had to shelter in place because there was an active shooter in the building. Only later I found that Security Officer Bradley Haas had died heroically while protecting all the patients and staff at New Hampshire Hospital. After the tragedy at New Hampshire Hospital, the state investigated what happened, and the Attorney General Office released a report regarding their investigation. They determined that the gunman had a history of mental illness and had been a patient at New Hampshire Hospital previously. They determined that the gunman had purchased the pistol from a gun dealer in Barrington, New Hampshire, after affirming that he had never been committed to a mental institution. So it was determined that the gunman who fatally shot Chief Haas had obtained the weapon after lying about his own mental health history on the federal firearm application. Clearly, the current system is not working, and Chief Haas and the gunman died as a result. If the gunman's mental health data had been reported to the National Instant Check System, this tragedy may have been prevented. When a tragedy like this occurs, it is the responsibility of our elected leaders to investigate what caused the tragedy and to fix the problem, so it will not happen again. House Bill 159 is a solution to this problem. In closing, gun violence is a public health crisis, and the New Hampshire Psychiatric Society and Medical Society strongly support House Bill 159 as a way to potentially reduce the risks of suicide and homicide in the state of New Hampshire. Thank you. And I'm happy to take any questions.
See no questions. Thank you very much.
Thank you.
Holly Stevens.
Madam Chair, members of the committee, my name is Holly Stevens, and I'm the Director of Public Policy for NAMI New Hampshire, the National Alliance on Mental Illness. On behalf of NAMI New Hampshire, I'm here today to offer cautious support for House Bill 159. Yesterday at our legislative breakfast, we were asked why NAMI New Hampshire was offering cautious support for a bill that would impact a constitutional right of someone with a mental illness. Rather than summarizing my written testimony about the different protections in the bill, I'm going to answer this question for you today and let you read about the protections that NAMI New Hampshire feels are important at your leisure. NAMI New Hampshire is cautiously supportive of this bill because of the impact it will have on suicide. Approximately 85% of all attempts made with a firearm are fatal. Firearms are the most common method used in suicide attempts, and in the Granite State, 87% of all gun deaths are suicide deaths, compared to 56% nationally. And I also wanted to talk with you about the IEA process and how it relates to this bill. First, a petition is completed by the petitioner and a medical provider. and then it is signed by a judge or a justice of the peace. At this point, the person is transported to New Hampshire Hospital or another designated receiving facility. This bill does not affect people who are simply the subject of an IEA petition and transported to the hospital. This is part of the evaluation and assessment process. A person can be held for 72 hours once the IEA petition is completed. During this 72 hours, a probable cause hearing must be held to determine if the person can be held beyond the 72-hour period and for up to 10 days. Each person is represented by counsel during this probable cause hearing. If the court finds probable cause to continue the hospitalization, the person can be kept through those 10 days. Again, this is also part of that assessment and evaluation process. This bill does not affect these people who have had a probable cause hearing and have been found for them to be kept up through that 10 days. After 10 days, if the hospital personnel believe the person is still not safe to be discharged, a probate commitment is held to determine if the person can be held at the hospital for up to 5 years. The person is also represented by counsel at this hearing. The bill only affects the people who the court determines can continue to be held involuntarily beyond the 10 days and for up to 5 years. To be clear, it is not all people subject to an IEA. Also, at any time during the IEA process, a person can decide to remain at the hospital on a voluntary basis. They can change their minds. And so long as that happens before that probate, that second hearing happens, this bill would have zero impact on them. That was just where I was ending. I hope that helps you understand why we are cautiously supportive of this bill.
Thank you very much. Honorable J.R. Hall. Just before you begin, I just want to remind everybody there was an amendment passed out, just so everybody that maybe does not have that knows that now. And whenever you're ready.
Sure. Thank you, Madam Chair. For the record, I have not, J.R. Hull, Town of Dunbarton, representing the New Hampshire Firearms Coalition. I have not seen the amendment yet, so I'm going to speak to the bill as filed. Fundamentally, the bill itself is so flawed that I'm not sure an amendment can fix it, and I will say that again. The bill and the concept is so fundamentally flawed that there is no way to fix it with an amendment. New Hampshire Firearms Coalition opposes HB 159. The bill is a red flag bill under the guise of a mental health. It is the same bill that was filed last year, almost verbatim with one word change, as HB 1711. This bill attempts to capitalize on the murder of a retired police chief, Officer Haas. The bill would allow psychologists and state bureaucrats to strip law-abiding citizens of their constitutional Second Amendment rights. First, the bill violates two provisions of the New Hampshire Constitution. Article 14, by having no recourse, right, every subject in the state is entitled to certain remedy, having recourse to the laws for all injuries he may receive in person, property, or character, to obtain right and justice freely without being obligated to purchase it. If a person is being stripped of their rights, do they have to go hire the attorney, or is the state going to provide the attorney and pay reasonable attorney's fees so that they can be represented in a court during this process? Secondly, it also violates Article 15 that no subject shall be held to answer for any crime going on, despoiled or deprived of his property. The way the process is laid out in the bill, their firearms are taken or removed without any say. Additionally, the bill attempts to use the fundamental broken criminal database. In the packet that I handed out, there was a report from 2018 relative to NICS, and this was put out by the Government Accountability Office. In the 8.6 million transactions, they denied 112,000 people. Of that 112,000 people, they investigated a mere 12,000, so roughly 10%. And of those, they only prosecuted 12. So of the 112,000 people that were denied the chance to buy a firearm, and it's a felony if you are a prohibited person attempting to buy a firearm, they prosecuted 12. This isn't obviously a deterrent. So there are fundamental processes that are broken within the NICS system. The database is corrupt. People are wrongfully denied routinely. Next, using a criminal database, the National Instant Criminal Database, to track mental health is wrong. It is simply wrong to put mental health information and people who are having mental health issues into a criminal database. It potentially affects employment long-term. It potentially affects other things that may go on in their life. We should not do that. The potential issue of a person being so dangerous and needing to be put in a criminal database because of a mental health issue would be better resolved by getting them the help they need through the mental health system, as opposed to taking away their constitutionally protected rights. Next, there's an email floating around in response to our emails that says you have to be involuntarily committed for 30 days to trigger this mechanism. That is not what the bill reads. If you listen to the speaker before me, there are provisions within the mental health statutes under 135, C 34, 35, 36, and probably some sections earlier, that there is a process defined. None of it is 30 days long. Next, although the federal law, right, can you get your rights restored? There's a section in this bill that says you can. Although federal law provides for a means of release from firearms, and I'm quoting the ATF, I sent you the copy. ATF's annual appropriation since October of 1992 has prohibited the expending of any funds to investigate or act upon the applications for relief. That means once you go into the system, you're stuck. Let's not do that. Let's not do that to our mental health, people struggling with mental health issues. Lastly, in closing, if a person was truly a risk to others, this will do nothing to stop them from harming others if that is their intention. As we have seen in recent events, vehicle homicides, that showed up more recently in the news, right? People can be harmed, okay? Do we stop people from buying cars just because they have been used to commit homicides? As I pointed out in my notes, the state has no duty to protect under Castle Rock v. Gonzalez. And for those not familiar with the case, I'm going to read quickly the summary of the article, right? This is a case from 2005. In a 7-2 decision where a lady tried to get her estranged husband a restraining order and he murdered her 3 children. She took the town to court because obviously the police had a duty to enforce the restraining order, and the Supreme Court of the United States said there is no duty for the state to protect somebody. That is left up to the individual. This bill harms the gun owners, harms the citizens in New Hampshire. I would ask that you'd find it inexpedient to legislate. Thank you.
Just in time. Just in time. See no questions. Thank you very much. Dr. Fetter?
Hello, my name's Jeffrey Fetter. I'm the Chief Medical Officer at New Hampshire Hospital, and I've testified here under various hats, but today under the hat of being a member of the New Hampshire Medical and Psychiatric Societies. I urge you to support HR 159. I was at New Hampshire Hospital during the shooting, and I'm not going to recap that story except to say that we do now know that the individual lied about their mental status history. But I actually mostly think about this bill as a suicide prevention bill. New Hampshire had 134 suicides in 2022, the last good data year that I'm able to access. That's one suicide by firearm every 3 days in New Hampshire. What we do know is that preventing access to the preferred method of suicide prevents total suicides. This is a non-controversial piece of science at this point. It's on my board exam I have to take every 10 years, that when they cut off the ability for people to kill themselves by cold gas in England, almost 100 years ago now, suicide rates went down. When they put fences up around a bridge that people like to jump off as a suicide spot, they didn't move to the next bridge a couple blocks down. Cutting off the preferred method of suicide does not allow people to just do it some other way. It really matters. When illegal guns are prevalent in society, people might reasonably ask, what good does a bill like this do? But it's important to remember that folks with mental illness are not mostly criminals. They would feel just as weird as you or I walking onto the street corner and trying to buy an illegal gun. Cutting off the preferred means, if that is to buy a legal gun, would matter as a suicide prevention tactic. On a couple of technical issues, people ask what psychiatrists would do this. The courts do have a pool of psychiatrists they use for involuntary commitment hearings. I imagine that would be the same group of independent contracted psychiatrists they would use. On the confidentiality piece, I point your attention to the language that the person's name and identifier signifying their applicable prohibition under 18 USC 922G, social security number, and date of birth would be submitted. None of that is confidential medical information. It would not count as protected health information under HIPAA. It's often said in the wake of a shooting that we ought to not pass more laws, but enforce existing laws. That's exactly what this does. The Brady bill made that shooter a prohibited person, and we did not enforce it. This state should enforce that bill. Finally, I would just mention that it's often said that when these attacks happen, there's a call to strengthen mental health systems. I agree. After having worked all throughout this mental health system in this state, strengthen the mental health system by giving it one more tool, the ability to report people we know to be dangerous and the police don't yet know.
Thank you, Dr. Fetter. I see a lot of guests here that have not turned in a card. If you do intend to speak on this bill, please do so now, because we are getting down to the last few and we're trying very hard to do support, oppose, support, oppose. Mr. Simpkin.
Good afternoon, Madam Chairwoman and members of the committee. Thank you for hearing my testimony. I am a federally licensed firearms dealer. I'm exempt from the NICS process, so I don't have a horse in the race for that reason. Key points. 1, firearm abundance makes HB 159FN, bluntly put, a waste of time. As at end 2023, there were approximately 512 million firearms in the United States. In my written testimony, a copy of which I will provide to each member of the committee, I explain what that number comprehends. But there's roughly 1.6 firearms for every human resident in the U.S., including infants who typically don't own much. Second, Chief Haas was murdered because Dartmouth Hitchcock forced him to be disarmed. He wasn't shot from behind. And I've read the Attorney General's report. The murderer acquired the firearm about 3 years before he abused it to murder Chief Haas. Chief Haas was basically made a sitting duck by someone at Dartmouth Hitchcock, and this committee ought to find out who that was. Third point, HB 159 offers fictive pathways for one adjudicated to regain the civil right to be armed. And the reason is that, first of all, critically, a person who is involuntarily committed is not likely to have the money to hire an attorney of their choice and to fund that attorney's hiring an expert psychiatrist. So the state needs to provide that money so that one who is involuntarily committed has a zealous attorney to defend them. What is in HB 159 doesn't do that. Fourth, the federal authorities cannot be made to delist anyone from a prohibited persons database. It's called the Supremacy Clause of the Sixth Amendment. So those who tell you that a person's name, once put into the database, can be taken out, I'll leave it to this way. The green leafy stuff they sprinkled on their breakfast pizza May have looked like oregano, but it wasn't. Fifth, federal authorities have specifically rejected a state's restoration of the civil right to be armed. I have personal direct knowledge because I appeared before the New Hampshire Supreme Court as a non-attorney representative for such a person. He had his civil right to be armed restored by Massachusetts. The feds told Massachusetts, decades after Massachusetts so enacted, no, we don't respect that.
Testimony, Mr. Simkin.
One more point, Madam Chairman. if
Mr.
I may.
Simkin, your time is up. Thank you very much for your testimony.
Thank you for giving me the opportunity.
Attorney Dean. My girl. That would be him. Put the bill on top of that. So Ms. Dean, we're just going to go ahead and get yourself settled. We're going to just wait a minute for this to come around because I don't want to distract from testimony while this is being passed out. Okay. Did you have to take out a finance to print all of that?
Turn on your mic.
She's
Turn on
giving.
your mic.
Hold on one second. We're not ready yet.
Well, she was talking to try and get.
Oh. Oh.
Nobody heard it.
Well, they wouldn't. They weren't. That's because. This packet isn't from you?
Not the mine have two pink sheets on.
Oh.
That packet's not mine.
Okay. I see that now. Okay, I can see that, you only needed to finance half of that packet. I understand.
Well, no, there's still two good sized
Yeah,
pink ones for
I
each
know, I
person. So, and
Come on,
hopefully
I was
haven't-
trying to throw you a bone. And...
Thank you. I bought stock in Xerox and HP last year. So
Everybody please take note. It's hot pink.
the very best color.
All right. All right. All right, 2 packets. Here we go. Oh my God. Almost. Hold on.
We used to be the most enforcement state in the nation.
Right. All right, everybody, you guys ready?
Oh, yeah.
All right. All right. Okay, whenever you're ready.
Good morning, members of the committee. My name is Penny Dean, and for those of you that don't know me, I'm a private attorney, solo practitioner based in Concord, New Hampshire. And I happen to love guns and love firearms, and I'm very, very fortunate to make a living doing the things I love. There is so much bad about this bill that I had to give you 2 packets. And I can't even begin, even if we were here all night, to tell you what's wrong with it. And I start off with, you always got to put yourself in the other man's shoes. And having grown up dirt poor and being abused by authorities, I can usually put myself in the other guy's shoes because we've been there. And so you ask yourself, how is this going to work for me? In one of the packets I gave you, if you notice, there's 2 pages. It's from the New Hampshire Bar News. And the New Hampshire Bar News said, and this was a 2023 printout, that there were 2,200 IEAs that year. Now, I have been trying to find out for years and years and years, just a number, not docket numbers or anything, and you can get the combination to Fort Knox easier, because I haven't been able to get numbers that I feel are good and reliable, And so, and they were begging lawyers, because there's not enough lawyers to represent those people. So tell me what we're going to do now. But the other thing is, as an attorney who's been there, conducting or representing people at these hearings, they expect you 15 minutes max. And if you think you want to take a half hour or an hour, the world's going to end there. They're going to throw a fit. So think about it, 15 minutes to decide whether or not you get locked away. Just put yourself in the shoes. But here's what's worse. They use this term about independent medical exam. Let me translate that into English. Here's what happens. They have their preferred people. And for example, the one that I used to deal with was a Dr. Geoffrey Barnett. And he was the one that when they bring him in, this is for the court, it's independent. Well, if it's independent, yeah, right. But then I got looking around. The doctor at the time, now they've changed their website, was the director of Aware Recovery Care. And that place just happened to have all sorts of courses and places that you could get treatment for if you wanted to get out of there. Think about that for a minute. And ask yourself if you want those, quote, independent people making decisions about your life. I can tell you there used to be a couple people in the state who will do these type of things who are fair-minded. You're looking at $20,000 for an exam and report and come in and testify. And you ask yourself, in addition to a lawyer, if you've got that type of money. Most people don't, especially at the worst time of their life when these type of things happen. So you go down the list, but here's what's most important to me. They're putting out this carrot. We've got a way for you to get your rights back. And I'm just a dumb country girl, and I think about things about how they go mechanically. And so I want you to really look at the packet that I put out for you. And look, secondly, at the petition for writ of certiorari that was filed by the New Hampshire Attorney General, which I found incredibly offensive. When my client's rights were restored by the New Hampshire Supreme Court, our New Hampshire Attorney General applied to the United States Supreme Court for a writ of certiorari to have it overruled. One more second, and then I'll
You're going to tell us where to go to in here, right?
It's the whole packet. It's the petition.
Okay.
And so if you ask why it's funny printed like that, the United States Supreme Court requires it to be printed like that.
Okay.
But what happened that I was told was quite unusual. We were ordered by the Supreme Court to write a brief in opposition, to write a petition in opposition. I was just going to wait to see if the court accepted the case. And the court said, oh, no, you're going to write one in opposition. So I'm happy to answer questions. There's so many procedural things wrong, but it's horrible.
I don't see any questions, but we certainly have your telephone number you've made available, and if anybody does have any questions, I'm sure you're okay if they reach out.
Absolutely.
Okay.
No, I'm happy to answer questions.
All
Always.
right. Well, seeing none, thank you very much. Thank you for coming in today. Dr. Hannon?
We good? All right.
You're all set. Thank you.
All right. My name is Joe Hannon. I'm the Vice President for Gun Owners of New Hampshire. I'm speaking in opposition to House Bill 159. I don't want to speak to the amendment because we haven't really had time. I do appreciate getting it just prior to this. I'm not going to repeat a lot of things that were said. I'd like to talk about a couple of other things that I don't believe were mentioned a lot. We heard about the burdensomeness, invasiveness, and potentially discouraging of individuals from seeking mental health treatment. That's something that if people are worried about people getting the care they need and getting mental health treatment, this is something that can actually prohibit people from wanting to come forward if they're worried about what's going to happen to me. And it doesn't necessarily have to be for guns. It could be for any number of things. We also have to worry about the disparity of subgroups of people who are not as easily able to get back their rights, to have rights restored if there is a process that actually works. It comes down to money, it comes down to access and information. Not everyone's going to be treated the same with getting their rights back. If someone has $1 million in the bank, it's not going to be a big deal. If someone's homeless or poor, it's definitely going to be an obstacle. Last, and also I want to mention that, I'm not speaking ill of psychiatry or mental health. Some of my good friends and people I associate with are in those fields. But I would like to say that the history of mental illness being used as in a sense being weaponized, so to speak, is not something new. Different mental illnesses that are not considered criminal or are mental illnesses even now were on the books for a long time. Homosexuality up until 1973 was classified as a mental illness by the APA. Hysteria in the 19th and 20th centuries, women exhibiting symptoms like anxiety, fainting, and nervousness were often diagnosed with this and institutionalized. Epilepsy, people were often viewed as criminally or as possessed or criminally insane and led to their confinement in asylums. Same with alcoholism, leading to institutionalization. Mental health in general, many behaviors that were considered or labeled mental illness leading to widespread institutionalization without proper diagnosis or treatment. I'm not saying we're not diagnosing and treating people as properly today. It's obviously many improvements have been made, but things change over time. What may be considered a problem today may not be considered a problem in 20 or 30 or 40 years from now. I also don't think it's important that that we don't make some of the mistakes that we had with ourselves in New Hampshire. If people remember the Laconia School, there was a big property in the Lakes region that housed people with mental illness, alcoholism, epilepsy, people that they just thought weren't of the right moral character. All kinds of illnesses and diagnoses were used to put people in an institution. I don't know. I don't want to get into debate about what do we do with these individuals? We've heard lock them up. We've heard different things, but I think that's beyond the scope of what we're doing today. I think we have to realize that we've had an absolutely horrible past, especially considering New Hampshire. And it wasn't just putting them in institution. People were sterilized, put in inhumane conditions. Granted, we've gotten rid of that and we've moved on, but we haven't moved on from the fact that we've criminalized mental illness.
Thank you very much. Any questions, anybody? All good? All right. Seeing no questions, thank you very much. Is there anybody here wishing to testify on House Bill 159 that has not yet turned in a pink card? Seeing none, I will close the public hearing. Thank you all for coming and respecting our 3-minute time frame. I know it's hard when there is so much to say. Guys, if you want to take a quick minute bio break, and then I'll go gather up our chairman, and then we can come back in and try to get some of these bills out so we can get them off our docket. Awesome.
I'm opening executive session on House Bill 338, and I recognize myself to make a motion of inexpedient to legislate.
Second.
I'll speak to my motion. This is the bill that is trying to make our fish and game police officers do everything by getting probable cause before they actually are able to investigate, to do their job, to get probable cause. I think we all heard the colonel testify. And for those of us who have been here, this is like the third or fourth year this bill has come around. And frankly, it's just not workable. Would you like to speak to your second?
Thank you, Mr. Chairman. I just want to say that I feel like there is this injustice that's trying to be created for others that don't feel that. And I just think it'd be a shame to dampen their professional careers and their livelihoods over someone else's feeling.
That's a very good point. The fact that the people who this would impact, the fishing industry, came here and begged us to not do it and please leave them alone. And I didn't see one single hunter who was here who was aggrieved as well. So anyone else like to speak on that?
Yes, Chairman Roy.
Yes.
Speaking as a seacoaster, and obviously we're concerned for the welfare of our fishing communities as well, and they did not seem to be, again, in support. It looks like there's no need for the. Looks like if the bill was to require a warrant, they wouldn't want that. But it looks like the bill wasn't even requesting a warrant, also in the first place. So.
Thank you. Any further discussion? Seeing none, I'd ask the clerk to call the roll. The motion on the floor is inexpedient to legislate on House Bill 338.
Vice Chair Rhodes?
Yes.
Representative Prue?
Yes.
Representative DeSimone?
Yes.
Representative Devoid?
Yes.
Representative Bogart?
Yes.
Representative Paquette?
Yes.
Representative Saborin Deschwanier?
Yes.
Representative Matson?
Yes.
Representative Harriet Gathright?
Yes.
Representative Muse?
Yes.
Representative Newman?
Yes.
Representative Murphy?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Shear?
Yes.
Chairman Roy?
Chair votes yes.
16-0.
16-0, unanimous. Any objection to consent? Seeing none, will go on consent. I hereby close the executive session on House Bill 338. I hereby open the executive session on House Bill 257 and recognize myself to make a motion of ought to pass.
Second.
Seconded by Representative Prue. I'll speak to my motion. This is with regard to the criminal neglect of a child. This bill would, and what's interesting is we did hear some testimony today during the other bill with regard to how difficult it is to bring criminal charges against parents when it comes to cases of neglect. We heard from 2 county attorneys requesting that we pass this bill because they find it almost impossible to bring charges against parents because of the dual track system. And I've spoken with our executive branch as well, and they're interested in this bill passing. It just seems to me that anything we can do that doesn't interfere unnecessarily in the parental rights, we should. And this allowing the criminal charging for neglect of a child is very important in my mind. Would you like to speak to your second?
No, I think you covered it quite well.
I appreciate it. Thank you. Discussion. Representative Scher.
I think, as everybody knows, I oppose this bill. I think I am not, given my history working in the criminal legal system, I have never been impressed with the ability of prosecutors' offices to handle issues that are better handled in interdisciplinary fashion in organizations like DCYF, number one. Number two, the criminal system is less able and has less resources available to manage somebody who's convicted of child neglect in terms of managing the family, managing them getting out of a situation where they're causing child abuse. Number two. Number three, I think there is a way, and we heard some significant egregious cases. I think there is a way to deal with more egregious cases than the law currently allows for. Both county attorneys testified that the child endangerment statute has a mental state of purposely, which is difficult to prove. And I have been very supportive, and some have agreed with me, that the mental state in that statute be changed to recklessly, which will bring in more of the more egregious cases without making the county attorney's office the superintendent of what is good parenting and what is neglectful parenting. So I'm going to oppose this bill.
Thank you. Further. Representative Muse.
I'll be regretfully voting against this bill. I really support the intent of what the sponsor is trying to do here, but I think this is a bill that needs some serious work, and I think all of the issues that Representative Scher and others on the committee raised during the hearing, some of the issues that were raised by the witnesses are issues that really deserve to be addressed. One of the biggest concerns for me was in the online testimony. The Office of the Child Advocate basically weighed in that it was opposed to the bill as currently written. These are the people who are supposed to be looking after the interests of kids, probably more than anybody else in this state. And to not have them on board with us, to me, is a big red flag. So my preference would be we keep working on it, but if we're not going to keep working on it, I think we should ITL it.
Thank you. I would say that, and you'll pardon me for relying on them, Representative Scher, but you're two former law students who actually county attorneys now and were supportive of the bill. And they are responsible for looking after the welfare of children with regard to whether or not they're being criminally abused or neglected. And they both, who have tried numerous cases, have said that this is necessary for them to be able to protect the rights of these children who have been criminally negligently harmed. So, Representative Chaborn de Chaner, something like that.
Thank you, Chairman Roy. Well, what was the outcome of the subcommittee? What was the recommendation following the outcome?
The recommendation is ought to pass after having spoken with all those parties involved.
Okay.
Representative Newman. Sorry.
It's all right. Pretty close. I guess I just wanted to weigh in because I really wish that I could vote for this bill, in support of this bill. But I think that there are certain considerations that need to be ironed out, and I was hoping that the subcommittee would do that. And so, yeah, I'm really conflicted about it, but I just wanted to, I don't know, say that.
Thank you. We appreciate it. Seeing no further, I'd ask the clerk to call the roll. The motion on the floor is ought to pass.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative DeSimone,
Yes.
Representative DeVoid,
Yes.
Representative Bogert,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschwanier,
Worth having a floor vote discussion? Yes.
Representative Matson,
Yes.
Sorry, yes, ma'am.
Representative Harry Gathright,
No.
Representative Muse,
No.
Representative Newman,
No.
Representative Murphy,
It's a really tough one for me. And I could, you know, I wish we could come back to me, but this is really hard because the intent of this bill is so good. I recognize there are criminal child neglect cases. Oh God. I'm sorry. This is horrible. Okay, I'm gonna say yes.
the clerk votes yes. Representative Newell,
No.
Representative Scher,
No.
Chairman Roy,
Chair votes yes.
11-5.
11-5, motion carries. Who will be writing the minority report? I take it Representative Sherwood?
I will.
Okay. And, it looks like I made that motion. I'll be writing the opposite. Now to close the public hearing. I hereby open the public hearing on House Bill 103. I recognize Representative Prue to make a motion. 103. Oh, that's because it was, you, no, hold on, stand by.
If I may offer an apology, I got that bill number confused with the bill that I did give you, and I take responsibility for that as my fault. Chairman Roy, I would ask that you give a professional courtesy for them to have a few minutes. It is House Bill 103, and we just completely forgot that I made that mistake.
The motion was going to be inexpedient to legislate.
Yeah,
correct?
it is going to be
I anticipate
ITL,
They will
but-
be making the same thing. It's the one where they. Yeah. I think we're on the same sheet. Yeah.
That was my mistake. I got a lot of numbers confused today, guys. I apologize.
I'm sure. Let's see, let's see.
And then I tried to fix it and still give the wrong bill number, so.
It's always two.
Wow, I mean, do you see this, I mean, this is ridiculous.
Are you guys good? Yeah.
Oh, we're not going to be doing that one today at all. The one I made a mistake was I gave you
102.
640.
Yeah.
And that was the mistake. We are not doing that today.
Okay. All right. Where was I? All right. Representative Prue.
So I don't get out, I'm having to write that.
It was close.
report. I'm going to make a motion of inexpedient to legislate.
Second.
Would you like to speak to your motion?
Sure, just a little bit. My first concern was crossing out the Constitution of the United States. To me, that makes this bill pretty much unconstitutional. So we as state reps have a responsibility not to be passing unconstitutional bills. So, and the rest of it, it just kind of muddies the water and, you know, interferes with, you know, getting extradition. Gee whiz, that word went right out of my head. Yeah, and we killed about 2 forests today. So yeah.
Thank you. Representative Paquette, would you like to speak to your second?
I agree with what he said.
Wise decision. Yes.
Thank you, Mr. Chairman. I would just like to add that Representative Prue is exactly right. And as the vice chairman, it is actually one of my rules that is written into our house rules that if a bill is unconstitutional, we're not supposed to pass it. And it's my job to tell everybody that it is. And actually the Constitution is stricken from that right in the bill that we can't do that. And you know, we can't have it both ways. We can't be yelling about the Constitution on one hand and then in the very next hand in the same body be taking out the Constitution when it doesn't fit something that we want it to be. So I appreciate the sponsor's intent and his reasoning, but unfortunately, I hope that he understands it's an unconstitutional bill the way he wrote it.
Thank you. Seeing no further discussion, I'd ask the clerk to call the roll. The motion on the floor is what? Who? Oh,
New Hampshire has a proud tradition of allowing every bill submitted to have a public hearing, and you know, it's certainly okay to have bills come to the floor and have a hearing. This is just one of those bills where it can't go any further. It's okay to have bad ideas.
okay. Ask the clerk to call the roll. Motion on the floor is inexpedient to legislate.
Vice Chair Rhodes,
Yes.
Representative Prue,
Yes.
Representative DeSimone,
Yes.
Representative Devoid,
Yes.
Representative Bogert,
Yes.
Representative Paquette,
Yes.
Representative Saborn Deschwanier,
Yes.
Representative Matson,
Yes.
Representative Harriet Gathray,
Yes.
Representative Muse,
Yes.
Representative Newman,
Yes.
Representative Murphy.
Yes.
The clerk votes yes. Representative Newell,
Yes.
Representative Shear,
Yes.
Chairman Roy,
Chair votes yes.
16-0.
16-0, the motion carries. Inexpedient to legislate. Any objection to consent? Seeing none, it will go on consent. And one last one. Did everyone get the amendment I handed out with regard to Director Skipper's? Yeah. If everyone has it, I'm going to go ahead and make a motion then.
The amendment number is 0329.
Does everyone have it? Okay. I open the executive session on House Bill 778. Is that what it is? Yep. And move ought to pass with amendment. And I'm offering amendment number 0329H. Thank you. I'll speak to the amendment. Director Skipper was here and he let us know that this amendment with regard to their details just clarifies that they can only do the details when they're invited to do so by a local municipality. Want to speak to you a second?
Sounds good to me.
Okay, very good. Any discussion on the amendment? Seeing none, I'd ask clerk to call the roll. It's to adopt the amendment.
Vice Chair Rhodes?
Yes.
Representative Prue?
Yes.
Representative DeSimone?
Yes.
Representative Devoyd?
Yes.
Representative Bogert?
Yes.
Representative Paquette?
Yes.
Representative Saborn Duchonier?
Yes.
Representative Matson?
Yes.
Representative Harriet Gathright?
Yes.
Representative Muse?
Yes.
Representative Newman?
Yes.
Representative Murphy?
Yes.
The clerk votes yes. Representative Newell?
Yes.
Representative Shear?
Yes.
Chairman Roy?
Chair votes yes.
16-0.
The amendment is adopted. I make a motion ought to pass with amendment. Seconded by Representative Murray. I'll speak to the motion. This bill, as you recall, just enables the police officers that work at the Police Standards and Training Council to not only do details, but bill for them from the municipalities. Currently, they're technically able to, as they are certified law enforcement officers, but they're unable to accept details that are offered to them because they have no way of getting remuneration therefore. Would you like to speak to your second?
I absolutely agree that, law enforcement officers should be getting paid according to the work that they're doing, and this sounds good to me. Also, Representative DeSimone, I think, had a point of order. Oh, you're all set? Okay.
Further discussion? Seeing none, I ask the clerk to call the roll. Motion on the floor is ought to pass with amendment.
Vice Chair Rhodes?
Yes.
Representative Prue?
Yes.
Representative DeSimone?
Yes.
Representative Devoyd?
Yes.
Representative Bogert?
Yes.
Representative Paquette?
Yes.
Representative Saborn Duchonier?
Yes.
Representative Matson?
Yes.
Representative Harriet Gathright? Representative Muse?
Yes.
Representative Newman?
Yes.
Representative Murphy?
Yes.
The clerk votes yes. Representative Newell? Representative Shear? Chairman Roy? 16-0.